I was supposed to file a PDP, so I require another 4 weeks time.
Just for the other side. There is an interim order.
Interim order. Yes.
On the prayer of PSC Cal, you appear as
Senior Standing Counsel for Income.
income tax. Senior standing counsel income tax matter adjourned by 4 weeks to enable filing of affidavit. Region several and senior counsel for the petition. However, submit that in report which record section. Interim order last 10 section.
Much.
Shall we fix the date? Use the date for 4 weeks. Can have it on 15th of December.
Sure.
Based on 15th of
Much.
May it be lost, my lord. Item number 24 in today's list, my lord.
Yes.
That in that we have filed a reply, but we could not solve the copy to the private counsel, private
counsel for the private response.
Yes.
Who is appearing?
Anjan Bora. So we could not find him yesterday.
21.
My lord, can it be on 22, my lord? No confidence motion being
Have you filed it by this?
Yes, by 22.
Pre arbiter but senior counsel of petitioner sub that do the rejoinder affidavit ready,
File valid.
rejoinder affidavit has been filed, copy could not serve on the lieutenant counsel for
Private.
response. But is he been informed?
No, my lord, because since the copy informed.
Sarah, according to direct that the matter is on to its second along with the copy of the judgment. Is there any interim protection?
No.
May I please the Lord? In fact, to mention item number 20, today's list,
Yes.
in which my lord, some other order were passed during pendency of the petition matter. So I have the instruction to withdraw this.
Here for the
No man. APDC is there.
APTCL.
I'll
Anybody?
inform my standing counsel.
Is anybody there? APTCL? Anyone in the court?
20.
To record the presence of the KP Pathak.
Yes, sir.
JMH Chaudhary when it comes to the petitioner subject that due to some subsequent development, he has instruction not to present. Sarah? When it comes to for KPTCL, petition record is dismissed on it.
Obligement.
Yes.
May I please the Lord?
Ask Mr. Pathak to come to court.
May I, item number 10, your lordship.
10.
In this case, I withdrew the petition with the liberty to file a case because there is some technically.
N. Upadhyaya, when it comes to petitioner submit that due to some technical problem, did it record to return the liberty file of press. You are there?
Yes, sir.
Also heard as Guru yes, recorded liberty estate for
Obliged.
May I please, your lord?
Yes.
My lord, for item number 18, extravagating matter, my lord.
it is.
My lord, in this case, my lord, I have filed, my lord, affidavit in opposition, my lord. Today, this morning, my lord. This may, my lord, maybe call for the record, my lord.
Lordship, I have
Kindly oblige.
Lordship. Yeah. But okay, Lordship, because attendance is there, Lord. Is that matter?
He has not sought adjournment.
Yes.
Not for example.
No.
May I please, your lordship? Lordship, I am praying for listing of a matter, lordship, which is pending in last 1 year. It is not listed. It pertains to election and appointment of Gaubura, lordship.
Pertains to this bench. Bench period.
I'm sorry.
May it please your lordship. Well, this is one of those unfortunate incidents where, unable to bear the torture of her husband, the
wife attempted to commit suicide. The mother, who was a school teacher, saw it, cut the rope, she fell, and she had to undergo treatment. And now she is completely in a bedridden, can't speak, can't recognize, fully paralyzed. They both were doctors serving in Namcare. The mother was a teacher. While she was earning, my lord, she did not ask anything from her son-in-law. Now, after her retirement, she is unable to bear the cost of her maintenance of the daughter. And in the meantime, the husband deserted her. The attending doctors and the patient advised that if the minor daughter is with the mother, then she may have chances of recovery. She took it, now living a adulterous life with a mistress, came to us, my lord, and for us it's a pro bono. We asked her to file a petition before the Principal Judge Family Court, Kamrup at Guwahati.
So what is
The-
the difficulty, Mr. Das?
Lord, the issue is, my lord, he is physically incapacitated.
No, 125 can't be adjudicated.
My lord, I have received one instruction, my lord. This
Now, what is the difficulty in adjudicating?
the difficulty? I think, my lord, so far as I have seen, my lord, the
See, they
affidavit-
are not claiming anything. They are only seeking that the 125 petition be considered and necessary orders passed.
Yes.
Where is the difficulty in consideration?
because under 126 CRPC,
125.
125 CRPC is the provision, my lord. 126 CRPC, the procedure is that the person has to be physically present for the family court.
No. Here is an exceptional circumstance.
True, my lord. That I can
That
appreciate.
much of
So far as
application of mine can I. Where is the requirement of being physically present?
126, if you lord,
126 is a variation of the order.
125.
120,
And my lord, under the Family Courts Act, the Family Court can also devise its own procedure. It can appoint a commission to go and see personally the condition of the wife, my lord, the petition. Family
Yes,
Court.
where is Mr.
No, personal presence is not required, my lord.
126 2, my lord.
Yes.
All evidence to such proceedings shall be taken in the presence of the person against whom an order for payment of maintenance is proposed to be made, or when his personal attendance is dispensed with in the presence of his leader, and shall be recorded in the manner prescribed for summary cases.
Yes.
Provided that if the magistrate is satisfied that the person against whom an order for payment of maintenance is proposed to be made is avoiding service or willfully neglecting to attend the court, the magistrate may proceed to hear and determine the case expertise, and any orders so made may be set aside for good cause shown on an application made within 3 months from the date thereof, subject to such terms, including terms as to payment of cost to the opposite party as the magistrate may think just and proper. The court is dealing with application under section 125 shall have power to make such order as to cost as may be just.
Hmm.
If you also kindly read the Family Court Act,
Section 10.
Section?
10.
section 10, my lord.
Yes.
Subject to
Yes.
subject to the other provisions of this act and the rules, the provisions of the Code of Civil Procedure 1908 and of any other law for the time being in force shall apply to the suit and proceedings within bracket, my lord, other than proceedings under chapter 9 of the Code of Criminal Procedure 1973 before a family court, and for the purpose of state provisions of the code, a family court shall be deemed to a civil court and shall have all powers of such court. Number 2, subject to other provisions of this act and rules, the provisions of Code of Criminal Procedure 1973 or the rules made thereunder shall apply to the proceedings under chapter 9 of that code before a family court. So, my lord, my understanding
you-
is that so far as 125 CRPC proceedings are concerned, the procedure will be guided by the provisions of the CRPC. And so far as physical presence of the petitioner, taking into consideration the peculiar fact of the case is concerned, my lord, I can appreciate that fact. But so far as, my lord, swearing of the affidavit of the petition by the mother is concerned, I have got some reservations.
Now, where is the provision?
Your lordship may look at 3:10.
Where is the provision of the person being present?
Evidence has to be,
That is the state of evidence.
that's true.
That is the state of evidence.
That-
Now only notice will be issued.
That-
We do not even know factually whether it's correct or not.
No.
He may have a false case.
True.
It's up to him. The initial onus is upon him. Only when it tells the onus,
Ultimately, if the petition is filed also, there will be objections and all those things.
all
and-
those things. Why is the
It-
difficulty in
But only,
entertaining the
only issue your lordship may consider whether the affidavit can be shown in, if otherwise, my lord, not inconvenient to your
This
lordship.
is a fixed matter, a pleaded case. Person is in the hospital lying on bed.
My lord,
Are you? Is it
there is a-
required?
we
Is it
have got a-
expected
we
in
have,
court to file an affidavit?
no, we have got a, my lord, provision that even if I cannot sign, then we can, my lord, affix some impression in the,
Oh, he may be in a vegetative state. What is
Yes,
it?
yes.
my lord,
What is the great difficulty? These are all handmaiden of justice.
no, I'll
Are we
just,
obstructing justice or are we
No.
dispensing it? What is it?
not at all, my lord. I have got instruction, my lord, doctor will kindly have a look. These are only in tune with the view expressed by your lordship.
See, the person against whom a proceeding is made, his presence, everything is there. Now it's a complainant who is asking for the entertainment of the case.
Registering is, my lord, true. But the
Poor
pleadings in the, one
poor-
aspect, my lord,
Yes,
Poor,
sir.
poor department,
principal judge family court and
private respondent is a party.
Yes, sir.
my lord.
We'll have to issue. We could have disposed this of. Can you serve justice upon the private respondent?
My lord, he is a doctor, my lord.
Can you serve justice?
My lord, it will be difficult. My lord, whatever be it, my lord. My objection is that now the petition has to be
No,
accepted
Mr.
by the
Kaur,
family
Mr.
court.
Kaur, we are inclined to allow this.
Yes, sir.
But since there is a respondent, private respondent, he is entitled to an
But we
and
can,
we pass the order in his presence. So that
but we
tomorrow
can make
there
an attempt. My lord, and similarly, my lord, this person, the gentleman, opposite party, there was a domestic violence case. The domestic violence, the concerned court has appreciated this fact that taken
Okay,
cognizance of the
PD for Senate Council, Senate Council for the petition. In the case of the petitioner, that but the petitioner is no, it is the case of the petitioner that she is in a paralyzed physical state and is bedridden. So, due to some matrimonial dispute, an application under section 125 of the CRP is being presented on behalf of her by her mother in the family court Kamrup Metro on 29/4/2020, which however was declined to be taken on record. The senior counsel submits that there is no reasonable grounds not to entertain the petition in the facts and circumstances of the case. Three, H.K. Das, Learned Defense Counsel, Guwahati High Court, who has appeared pursuant to the direction of this court passed on 8/10/11/2020, has placed court the procedure governing a petition under section 125 of the CRP, which is laid out in section 120. He has also placed section 10 of the Family Court Act 19 relating to procedure to be followed. The Learned Standing Council has submitted that the presence of complainant may be necessary at the time of evidence. with the arrangement that notice of motion is written on, will give a date.
My lord, your lordship will give a short date. My lord, now I see that there is an address of the Nemke Hospital. We'll try to take
You-
a justice.
you tell us. We'll have it on 4th of December. Is it okay? Can you serve before 4th?
Yes, yes, my lord. Yes.
Or will it be too short?
No, we'll do it, my lord. This is a of speedy remedy, my
Okay.
lord.
4th of December. We each get a pending council. Want a good accept notice on behalf of for number 1.
My lord.
That step for service of notice upon the respondent to be taken by registered post state.
As well as justice.
Yes. Step press step by tomorrow. For compare. Additionally, the petitioner is given liberty to serve notice upon the respondent to by the state, which has to be routed to the registry of this court. The notice accompanying the justice is to clearly reflect the next date fixed. And the petitioner is also required to file an affidavit before the next date as proof of such justice. Considering subject matter involved, an endeavor would be made to dispose of the petition on the appearance of part
Your lordship has fixed it on 4th of December.
court of the
Deeply.
Highly.
give an extra copy to Mr. Das.
Yes, sir.
My lord, I am the writ petitioner here. I am, my lord, representing, my lord, 700 odd flat owners in the Games Village. This came before your lordship, my lord, in this court on 3 occasions. On the day 1, that is on 18/10/23, after hearing the matter there was a caveat also. After hearing the matters for some length, my lord, the order was passed by this court, which your lordship will find 18/10/23 order. Heard so and so. These were some common, no individual structures. These were, my lord, common structures for the entire campus.
What is the dispute?
My lord, dispute is, my lord, there are, my lord, 2 independent, my lord, pages. Page 1. We were allotted, my lord, and we were in fact we are the owner of the flat, and 700, my lord, flat owners are there. Those were sold out to us after the, my lord, national games, 2007-8. Then we became the owner, and we registered a society of all the residents. And there are another that comprises around, my lord, 350 bighas of land. In the backyard, my lord, there was in the southwestern part, there was another, my lord, phase 2 land reserved for, my lord, more than 350 bighas of land. Now, my lord, the entire management, supervision, etc., by notification by GMDA was entrusted to the flat owner society. That means not only our individual flats, the roads, the car parks, the other amenities, my lord, community amenities, etc., etc. There were some promises made by, my lord, GMDA to provide for common amenities, which they didn't, my lord. So we erected certain community center, semi-permanent nature, my lord. There is a temple and there is a wall. Our case is that, my lord, initially the wall, my lord, separated both phase 1 and phase 2 areas. And it was existing earlier, and there were also fencing at certain stretches. So far as the phase 2 is concerned, ultimately the phase 2 area was allotted to, my lord, the private respondent, one, my lord, big construction company, real estate company, for building up 3 towers. And, my lord, they, in their area, they have already constructed. They have an approach road of their own, leading to the Basista Road. Now, my lord, with a promise that for some days, the backside passage will be used by them. The wall was broken and the car sets were also broken. Then, my lord, we reconstructed because what happened from the backyard, with the walls being, my lord, not there were trespasses, my lord. There were thefts committed. There were security concerns for all the.
Now, why did you demolish the wall?
They have demolished it. They have, my lord, there are allegations in the so-called that we have constructed without permission.
The boundary wall.
Boundary. And other structure, my lord, there is a children's park also. We, my lord, actually, GMDA.
Now, after the so-called notice, which was the subject matter of the earlier writ petition,
Yes.
what is the outcome?
After the so-called notice, we approached the Honorable Court.
No, that we have said the court
Without, my lord,
had
actually
remanded
getting-
back. Now, what is the outcome?
Then my lord, they issued an demolition notice. In fact, a notice asking us to remove within 30 days this structure. Against that, we approached. Then, my lord, there were certain, my lord, arguments from both the sides about the maintainability of the question. The private respondent raised that there is an appeal provision under the GMDA Act. Our case is that no, according to us, having entrusted the entire property with its management, GMDA has no longer any authority and jurisdiction. These will be questions, my lord. They will be argued on maintainability. I will argue on definitely on, my lord, the jurisdictional issue, and also about certain things. These are not individual violations, and whether I will try to show in under the building bylaws, there is a permission separate. Assuming they are thinking permission for a wall is up to a certain height is not necessary. I will even show that. Now, my lord, this court under this can we read this order now?
Order of the court?
Yes, appointed a court appointed commissioner, my.
Yes.
To the learned counsel. Second, learned counsel for the contesting parties have addressed elaborate arguments projecting the merit of their respective cases. While so-and-so learned counsel for the petitioner has argued that impugn order is without jurisdiction and seeks to take away the rights of the petitioner one society over the land and building standing thereupon, Mr. So-and-so learned caveator for respondent number 4 has argued that the writ petition is not maintainable due to availability of alternative remedy. It has also been alleged that it has been filed by suppressing material facts. According, there was no wall existing in that area, but the same has been subsequently constructed unauthorizedly without obtaining necessary permission. Further submits the unauthorized wall is obstructing the internal road built with the complex, causing injury to his client, which I disputed. Be that as it may, is the court's observation. Be that as it may, no presumption, no judicial preliminary objection. Since the projections made by the contesting parties raises some heavily disputed questions of fact, hence this court is of the opinion that an advocate commission ought to be appointed so as to undertake inspection of the site and thereafter submit a report before this court so as to enable this court to pass an effective order in this petition. The report to be prepared by advocate commissioner should address the issue raised in the show cause notice dated so-and-so impugn order, that is order to removal, and also refer to the other relevant aspects of the matter, bringing into light the background of the construction of the wall as well as the situation prevailing in the site. With the consent of the learned counsel of both sides, my lord, Mr. So-and-so, advocate of this court is hereby appointed to function as advocate commissioner to carry out inspection of the site and submit a report. Advocate commissioner so appointed, accompanied by a junior of his suite, shall be entitled to undertake multiple site visits for the purpose of preparation of the report. Both the parties to the proceeding to render fullest cooperation so as to enable him to discharge the responsibility entrusted. Report of the commissioner be presented before this court. This order was passed.
Now, the PFC report has been
Produced in a steel cover, my lord.
has it been opened?
It has not been opened. Thereafter the matter came. Thereafter the matter came twice before.
Yes, we have seen this order.
Yes, twice before, and that was not open. Now, my lord, my submission.
Let us first, Mr. Borpal, let us first open the, let us see the report.
Yes, my lord.
This report has been submitted in terms of a court order.
Court order.
Let us see what is the report of the commission.
But the order C.
No, Mr. Chaudhary, if even assuming it's not a consent order, the court can call for a report for, the report has been given, let us see the order.
That,
What does it say?
and after that, you
MK Jose. MK Jose. So what does it say?
I'll distinguish again.
Mr. Chaudhary, we are not finally disposing of this matter or it's going for a final hearing.
All the
An exercise has been conducted by a commissioner in terms of a court order.
my lord,
Now there is no point in not opening the thing. report.
my submission is, I leave
Whether
it,
we act upon the report or not, that's a different
Yes,
subject.
but
We have
I
not
leave
even
it to-
seen the report.
I leave it to your lordship, my lord. Before that, my submission is that, my lord, Supreme Court has laid down that, my lord, the court should not, my lord, go for a roving inquiry when there are
No,
disputed questions of
sorry,
fact.
until that order is put to challenge and set aside by a high court, we'll open. We'll not hear.
I have no objection. So,
We'll not hear.
So, my lord,
We'll not hear any objection.
let it be open and
my
let the,
submission will be, my lord, your lordship will open it. My submission will be, my
We can record this submission,
Yes,
but we are not agreeing with it.
so let
We
it,
have not
my lord,
even taken any cognizance of this report.
your lordship.
You are
may or
asking
may-
us not to know when to open. What is this? What was the exercise done? Why?
My lord,
You have objected, file an appeal. No commission is required.
no, my submission to your lordship is this matter is urgent, my lord, so far as it
No, we can go for final disposal tomorrow itself. If you are agreeing to.
True, my your lordship may take up.
But why
final-
shouldn't you open
final
this report?
Today also, your lordship.
Your
may discuss.
objection is making doing something else. We send something else as if there's something else in this report. You're
No,
a
my lord,
private
we do not
respondent.
know.
You are here
We
to
do not
contest.
know, my lord. We do not doubt
Then-
this bona fide.
Then why are you
question is,
why
my
are you
lord,
objecting to opening of the
Under my lord,
report?
order 46, my lord,
You
is
have
the
all the
report.
right to object, not to act upon this report. That's a different matter. But why shouldn't you open this report?
No, opening, my lord, I not.
No, you had said before opening you want to make
Before
objection.
opening, your
Sorry.
lordship will, my lord, may hear my submissions. That was my prayer, my lord. That was my submission. Because, my lord, when the matter came up before another court, my lord, court did not open it. Court said there is a Supreme Court decision.
Supreme
we'll
Court
hear
is
on
we
that.
see, you may be correct. We may ultimately dismiss this writ petition.
Yes.
It's on a final disposal.
Sure.
We may feel that it's a contractual matter. We may not like to enter. But our report has been submitted by an advocate commissioner pursuant to a court order. Now, not opening, what will it mean?
No, my lord, my submission will be, my lord.
The
Your
court
lordship will open
order
it.
cannot be made OTS like this.
My lord, no, my
And
lord,
yes, we would have if you had gone for an appeal against that order.
my lord, if your lordship allows me to
Let us have
submit,
a
my lord.
courteous glance. If needed, we can also allow all the parties consent to have a What is GPRWS? Or that is the
society,
petitioner?
my lord, games, village,
Okay,
residence, welfare
understood.
society.
The report may be in your favor.
I don't know. My submission was that it will be in favor of one of the parties, then all of the other party will
We-
question
we-
it. That take a lot of
Yes,
time.
that's a very tentative kind of, we have not carefully, I think you can have both, all the
My lord, what-
stakeholders can have a look at it.
I humbly submit. Let a,
Now you want
No, no.
report not to do.
no, I have one time, my lord, I agree to my lord.
What I
And about
submitted-
so far as the Supreme Court
Mr.
decision,
Barbara,
all-
Mr. Barbara,
My lord,
let us, let
OP.
me, let me propose something. See, this report is before us. We want the matter to be done in a very transparent manner. It's not something very hidden or something
that,
sacrosanct or classified. We'll allow all the stakeholders to have a,
my lord,
this is a fact finding kind of a thing.
My lord,
You can
what-
make a submission on
my
this.
lord, what I suggest, let a copy each be supplied to all the parties and give us some time. We'll argue.
We'll give a very
Oh,
short
That
time.
is
very
where-
short time, my lord.
That is where
My
my
lord-
No, no,
worry
short
was,
time.
my
We are
lord.
Very,
giving a
very short time. Lordship will dismiss my petition that they let them break the wall also. My lord, but
We are
I-
not dismissing your
let
opinion.
me-
Why should we
Let me
dismiss
do
your
justice
petition?
to my client.
We may allow your petition.
We may. So,
Thursday next.
No, my lord,
Thursday
yeah,
next.
I leave it to your worship, but then the fact is, my lord, he has argued on 2 points. One is that, my lord, the court has
We'll
no
consider everything.
court has no jurisdiction. I'll show, my lord, that has been decided by this
Very
court.
What intrigues this court is the smile of the AG. He's enjoying. I do not know why you are smiling.
Because before opening, I said that I am here for
Okay.
and number two, one, I am not taking the equipment.
Thursday. Thursday final discourse. But are you required to exchange pleadings?
My lord,
If you agree that
one affidavit. they
that
have
he will not
filed.
raise the objection of pleadings not been raised, then we'll go ahead.
we do not.
My lord, one affidavit they have filed.
On affidavit, fine.
Yes, one of it
I
only
will
bring.
file document, the original approved plan, and the submission.
File it.
Yes.
I think by before Thursday you can.
For the well, file them on.
For my lord, expeditious hearing, expeditious exchanges.
Third. PSC Board London City Council for the petitioners also had Sri D. Sekhya, London Advocate General Assam, and Sri M.K. Chaudhary, London City Council for the response numbers 4. 4. 4. Okay. This court, by the order dated 18/10/2020, had appointed an advocate commissioner to commissioner pursuant which, a report has been submitted in seal cover. The state report, the state seal cover is open and report has been perused. This court is of the opinion that a copy of the report be furnished all the stakeholders and the matter be taken up for final decision. Sri Chaudhary, the London City Council for the Private Response, has expressed urgency in the matter. Considering the same, list this case for, it will be in the motion stage, in the, for consideration on Thursday. Is it okay, Thursday?
Like to file it for.
Or will keep it on Thursday? Huh? The parties may in the meantime file affidavit or any documents by serving copies together. The copy of the report be furnished to all the learned counsel for the parties by the registrar during the course of.
There were some 30 days notice was extended for last 3 days. Somehow on 14th
The
it could
interim
not
order
be.
passed earlier can be extended till the next day.
Is not there.
I don't think they will
The interim
demolish.
is not there.
The interim order is there, continue to the next date of 14 left.
Yes, my lord, that was speak on that day, my lord.
Your lordship was not sitting that day actually. That could not be extended, very frankly. I believe
but
they will not
he-
demolish tomorrow.
No, he could have made a mention.
No,
my
I
lord,
think
to extend.
all these things,
Court tax should not cause prejudice to the party.
my juniors file a.
No, it's not court sack, my lord.
When the matter is the court of, we are not doing any court.
Interim order passed earlier stands extended till the next week.
Lordship.
Kindly depute any of your juniors to the court. It will be collected from the.
collect from here.
in this, from a court master.
May it please your lordship, the petitioner, may it please your lordship, the petitioner is before your lordship challenging the order dated 10th October 2023 passed by the Zonal Joint Register of Cooperative Societies, whereby the board of directors of the cooperative societies has been dissolved in spite of holding the meeting in the specific period as specified in the act, as well as intimating the same to the respondent authorities on the date of holding the meeting, lordship. And thereafter,
According to you, there was no default in holding the meeting. You had held the meeting in time,
lordship,
in spite of which they have dissolved the.
lordship, and holding the, we have hold the meeting in time, and thereafter we have intimated the same to the concerned respondent authorities, lord, on the day itself, lordship. But without considering our representation, they have passed this order, lordship. Moreover, lordship,
Where is the order?
at page 83, lordship.
83. Yes. Yes, please.
Can I go through it?
Yes.
Whereas the management of Vishwanath Dogaon KPSS Limited, registered under the Assam Cooperative Societies Act 2007, has failed to hold the annual general meeting for the year 2022-23 as required under provisions of the Assam Cooperative Societies Act 2007. Board of Directors of the state society is then automatically dissolved, Lord.
Yes, madam. What?
Lordship, on the last occasion, this honorable court has directed me to take instruction, Lordship,
Correct.
regarding the jurisdiction of the Zonal Joint Register to pass this order. Is there any notification to delegate him the power? Lordship, I have received that instruction, my lord. The another instruction this honorable court has directed to take me regarding the meeting which was held on 29th, my
Yes,
lord.
that is more important. Yes.
My lord, I have received both the instructions, my lord.
Meeting was held or not?
It was held due to law and order situation arises, lordship, the meeting could not complete, my lord. After that, they did not hang any notice to the notice board regarding the subsequent meeting.
But Mr. Bodlo is saying that not only the meeting was held, the holding of the meeting was also intimated to you.
No, lordship, it is not the fact, my lord.
Kindly,
Nothing was intimated to the, as per my instruction,
You filed the affidavit, well issue notice.
my lord.
When is your, how much is the tenure? 4 years.
Lordship, 5 years,
Right.
Lord.
When is it coming to an end?
5 years, Lordship. Last year, the board came into force, Lordship.
Only 1 year.
Only 1 year. 4 years remaining, Lordship.
Lordship may dispose of the matter, send back the matter to the register. He may look into it whether the meeting was held on time or not, whether the law and order situation arises or not.
You
take a
have instructions that the meeting was not
held.
you filed
I will file affidavit, my lord.
Lordship,
My
please,
lord.
then this may be.
No,
Lordship.
Lordship.
Otherwise, nothing will be left to us, Lordship. It was passed on 10th October,
We cannot
Lordship.
pass a stay order, we'll say something else. Third, PP portrait and council.
Lordship, may I submit one thing, Lordship? Lordship, the representation that I submitted on 39/2023 is annexed in this petition,
Yes.
Lordship. And it was clearly received by the concerned authorities, Lordship. That is the Assistant Registrar of Cooperative Societies, Vishwanath Charlie. And thereafter, as mandated by Societies Registration Act, we have submitted the minutes of the meeting within 15 days to the Assistant Registrar of Cooperative Societies, Lordship. Now, since the order has passed, Lordship, they may from the new society, Lord. They may from the new board of directors, Lordship.
Lordship, the one-man committee was appointed as per section 41(6), my lord, because the board was dissolved. And it will be, the election will be held
Okay,
in 90 days.
we'll give some
Lordship.
My lord.
portrait and council. The petitioner who is president of the Vishwanath Dogaon Krishi Farm Samabhai Samiti Limited, the district of Vishwanath, aggrieved by a community by an order 10/10/2020 by which the cooperative society in question has been held withdrawal and a 1-month committee has been appointed to manage the affairs of the society and to hold the AGM of the election within 19.
Lord.
It is the specific case of the petition that the ground on which the order has been passed is non-existent, and the society has actually convened the annual general body meeting, and the proceedings thereof were also communicated to the authority, in spite of which the order is passed. That notice is written by 4 weeks. MP Bora, no, food and civil supplies, only
My
Maria,
senior,
food and free, and click on accept notice on behalf of person number 1
four also.
and 4.
I am for
Whereas
three.
MP Bora, Planning Council, Cooperative, the Cooperation Department, accept notice on behalf of person number 2,
2,
3,
3, 5, 6, and
5,
7,
6,
my
and
lord.
7. That extra copy upon the learned concept of the by tomorrow. Border
Lord.
The learned concept for the petitioner placed for the report. After consideration of the facts and circumstances, so the resolution of the society is not state, direct, that no steps be taken to hold the AGM of the election of the society in question till the next term.
My lord.
And the
Obligement.
society would be continued to be run by the one man.
Lordship. I am deeply obliged, my lord.
Obliged.
May I please, this covered case, Lordship. The husband of the petitioner Lordship died in a motor accident, Lordship, on 4/9/22, Lordship. Person there to Lordship. He has filed a representation before the Deputy Commissioner for grant of ex gratia, Lordship, in terms of the notification dated 15/11/14.
Well, it should not. Your amendment,
Yes, Lordship.
amendment on petition who has approached this court for grant of ex gratia compensation because of the accidental death of her husband, Amit Bordoloi, on 4/9. The claim is on a notification date 15/11. That note returned by for
I for one.
and for one finance. Anyone finance? RM Bora. RM Bora. Correspond number 2. Then
I put 3, 4, 5.
and do some extra
Item 5 is also same.
area of parties.
Yes.
Parties are same, Lordship. In the same accident, the husband of the petitioner died.
Same accident.
Same accident.
Same
Two
accident.
persons, they were going by bicycle.
What is the
Lordship, they
name
were
of
knocked down.
this? Wife is before us.
Yes, wife
Widow
is before us.
What
The
is the name of the
name of the deceased will change only.
Professor Bordoloi.
Professor Bordoloi.
Professor Bordoloi? Respondent,
Same,
Uh,
Lord.
Same.
the trading area is same
Yes.
numbers are the same.
Yes, yes, Lordship. I would like.
Right.
May it please the court. My lord, the respondent is plaintiff, filed a suit for right, title and interest and for first position. Now, suit land, your lordship kindly see the valuation. Suit land is valued at rupees 4,20,000. My lord, we, as defendant, my lord, we filed our WS and counterclaim, which was valued at 25 lakhs and odd. Now, the trial court, my lord, dismissed the suit and decreed the counterclaim. Now, the respondent filed a title appeal number 1 of 2022 before the Court of London District Judge. My lord, we filed an objection that, my lord, district judge do not have any jurisdiction. If the suit valuation, I mean, counterclaim was valued at 25 lakhs and odd. So therefore, the district judge do not have any jurisdiction. Now, on the basis of, after hearing that objection, my lord, he has, my lord, returned that, saying that it should be filed to the proper forum. Now, accordingly, my lord, they filed RFA before this honorable court. Now, during the pendency of RFA, my lord, your lordship kindly see the MPO notification by the deputy registrar, which your lordship will get at page 91. He has transmitted the record to the district judge. There is a absolutely illegal notification. If your lordship look at page 91, my lord.
Yes.
From deputy registrar to the district and session judge Dhemaji, with reference to the subject cited above and subsequent to the enhancement of the pecuniary jurisdiction of the civil court,
Yes.
in the state of Assam, I am transmitting the records of RFA numbers to answer to your court. Now, if your lordship look at section 21 of my lord, Bengal, Agra and Assam Civil Court Act, I have already, my lord, quoted that in my petition also. Lord, I'll read it.
Page.
My lord, at
Before
Page
that,
7.
Just a minute.
my, my lord.
I have to get the instruction. Apparently, it appears that there may be some error because that 24/9/2021 notification I am having below. It
So
says
probably what had happened, we are just contemplating.
Lordship.
This June order was passed, taking into consideration the suit bill, not the counterclaim.
Exactly.
Exactly.
That's
My lord,
That
the
may be.
deputy registrar thought
Yes.
that the suit valuation is 4,20,000. So therefore,
Now your counterclaim has to be regarded as separate suit.
But my lord, it's a separate
And
suit.
separate suit, then if separate suit, then automatically that court may not have dismissed it.
Yes, obviously, my lord.
And I think the district judge was right in returning the appeal person to which
Yes.
the appeal was preferred in this court.
Very, very right.
Where is that order?
Which one, my lord?
The appeal order?
92.
91, my lord. Last page. Last page. Enacted 8.
It's not at the
My lord.
but have it at the stage of
My
you take out the
Wednesday, my lord will take up and get the.
your fight.
Yes.
How it be as total on the next round for the petition. The petition for the defendant in order to instituted for declaration of right and for custody. Petitioner had also filed a counter while suit was dismissed from the counter was decreed. The respondent had preferred an appeal for the learned Judge Dhemaj being calculated number 1 of 2002. 2002.
My lord. 22. No, it was earlier, it was just one.
You know, 22.
22 possibly.
2022,
22. My lord.
in which the petitioner had filed by consent that this counterclaim was valued at rupees 25 lakh 1,000. Correct?
Yes.
From the district judge, learned district does not have the pecuniary duty to act as the appellate court. Thereafter, though the respondent and on such objection, the appeal was returned, and thereafter the respondent had preferred RFA 7 of 2020. However, by the imputed communication dated the date 2/5/2020 issued by the Deputy Registrar written bracket admin -1 of this court, the matter was remitted back to the learned district judge Dhemaj. And senior counsel for the petitioner contest that the said order is palpably erroneous. The H.K. Das, senior counsel, Bhankya High Court,
Respond number 2, my lord.
who appears for the respond number 2, is for some time to obtain instruction. And this for consideration when Friday night?
Yes.
Friday night?
Right.
On Friday. On which date, depending on instruction, an endeavor would be made to dispose of.
I'm thinking whether I should make a prayer for stopping of further proceeding of the appeal.
One.
Very shortly, your lordship is disposing of. It's all right.
Anything will happen.
Obliged.
One extra copy may be.
Yes, yes. Surely.
Highly.
Obliged.
Yeah, plead your lordship. Lordship, non-considerations of this, my representation dated, my lord, 29/3/23, my lord, that is connector 3, page 19, my lord,
19,
my lord.
what is it?
My lord, some miscreants, my lord, separated with the petitioner and his mother, my lord. Earlier, my lord, petitioner only son, his 8 years old, my lord, killed, my lord. And now they are separated with petitioner and his mother.
Yes,
Yes, ma'am. I am appearing for the respondent, but today it has come. Also.
sure, short notice. These are matters,
Yes.
somebody was killed. Otherwise, you do not enter. But back perspective. And if you are,
L.
heard Miss was the Senate Council for petition, petitioner. It's the case of the petitioner that their minor son was killed by some miscreants on 7th connection with P. Silchar Sadar PS case number 491 has been registered under section 120-30 of Indian Penal. Apprehending murder, apprehending some further mischief, and a representation has been submitted to the Superintendent of Police, Qatar, on 29/2020, which has not been acted. According to this statement, that notice is returnable on 11th of December. The and Usman United States Council as the Usman learned AG Assam accepts notice on behalf of all the respondents. That extra copy same like
Obliged.
yes, Mr. Prophet.
May I please look? My lord, yeah, my lord, the petitioner before your lordship is a joint venture, my lord, and my employee, my lord, against whom I have given some power of attorney to look after my work, my lord. What he did, my lord, he has prepared fraudulent document and shown me I am retired from the partnership, my lord, along with other employees, my lord. Thereafter, my lord, he siphoned off some money, huge amount of money, my lord, and accordingly we subjected to the FIR. But the police authority, my lord, as on date, my lord, did not seize or did not act in accordance with the law, my lord. So we want, my lord, at this stage, my lord, investigation to be carried out by some other agencies, my lord, other than Assam police. That is the case, my lord. Lordship will see for a moment, my lord.
When did you launch the FIR?
FIR, my lord, that your lordship will see at page March 23, my lord, that your lordship will see at
March 23. What is the stage of the investigation?
my lord, investigation did not even seize the document from the bank.
What is
Railway
the stage?
stage, my lord, they have, my lord, police acted so rashly, my lord.
We are not saying that you are totally debarred from approaching this court under 26 for an alternative investigation, but those are under very limited circumstances.
My lord, here, my lord, the circumstance, lordship, also for a moment, my lord.
In
Lordship,
matters of financial of this nature,
not only finance, my lord, he has committed forgery, my lord, also from the record, my lord.
no, it is
Even
okay,
police
but,
personnel, my lord.
yes,
This is also there from my lord. Court.
you
Hello.
think if I will issue a short notice. See, there are restrictions on the street food in the
Certainly.
Sakira Basu case. But at the same time, it is a puja. CBI directions by a red court can be available limit. But yes, make out a,
My lord,
and it depends on what the status you have attained in the investigation. third,
I'm 227, my
A for B. AI for failure. By means of common, the petitioners have alleged performed investigation in respect of an FIR lodged by them on 136, wherein allegations of forgery leading huge financial loss has been made. This is a specific case of the business that though the FIR was lodged in March 2020, the preliminary seizure of the concerned accounts and documents have also not been done, leading rise of a genuine evidence on the effectiveness and fairness of investigation. The Goswami Leonard is Assam, however, submit that matters of this nature are not entered by a writ court as remedy lies in the code itself, COD, would be that notice returnable on whichever date,
My lord.
on 13th of December.
Lord.
Yes, rules for Union of India, Madam Sharma. And what P. Sharma? Anand Sharma. Miss Anand Sharma appearing on instruction of P. Kumar. Okay, Google. This is accept notice of behalf of respondent 1, 8, 9, 10, and 11.
12.
3 N. Goswami Leonard, government assistant. 3 B. Goswami Leonard, AAG Assam, accept notice on behalf of 227. Respondent number
7, 2, 3, 4, 5, 6,
7. And what about the others?
Private
Let
respondents
extra
are
copies be served up to the council by tomorrow. Let's have to take for service
12.
upon the respondent number
12, 13.
12, 13, 14, 15, 16, by registered check by Monday.
In the meantime, my lord, let them bring the status full. May I please, your honor? This relates to your lordship release of your lordship land acquisition compensation, your lordship. Land is acquired under Assam Mala program, your lordship, for upgradation of state highways and major district roads in the state, your lordship. And in fact, your lordship, award was passed, that was approved. Payment was made in the month of November.
50%.
50%.
50% has not been
Lord.
Third, 3 as Kotaku done it council for the petition, who is aggrieved by non-release of the compensation pertaining land acquisition for within inverted comma Assam Mala MALA program for upgradation of the state highways. The particular acquisition pertains to the district of Himachal. That notice be issued returnable on 13th of December 2023. Can ask for all
1, 3, and 4.
who is to Dina Senegal Assam notice 1, 3, and 4. Whereas and portal understanding concept except notice of number 2. Sarah and extra copy by tomorrow.
Obliged.
Lordship,
matter may be postponed for the time.
Bye bye.
Lordship Langet senior counsel is a fact.
Are you having some interim order or is it very difficult? DRT.
DRT. At the time.
The Sharma would come.
Lord.
He made some mention for recalling some gender. This case.
No.
Let him come.
May I please, Your Lordship, Her Lordship petitioner is the husband of the deceased who had expired in a road traffic accident on.
Ex-Christian?
Yes, Lord.
Yes, I can.
Yes. Yes, that's item number 2.
Ex-Christian. Are they ex-Christian?
5 and 6.
Normally, you write it the husband. This is a petitioner, the husband of the accident occurred on 4/4/2020. Because date of accident 4/4/2020. Petitioner is the husband of the deceased. This is your name.
Lordship, there,
Ayara Ahmed.
yes, Lordship, there is an typical error. There it will be Saniara. Mistakenly Y. CS NIY.
CHANIYAR. Saniara Ahmed.
Diplom.
Give copies.
Lordship.
Okay, here you will be available for the revenue department. Respondent. Who's there? And Mohanto, madam?
One.
Here, Mohanto. Who's to finance? Finance. Usually. Correspondent to Selling Council Finance. And as Burua, Ms. as Burua for 3, 4, and 5.
I'm up. Diplom.
Give extra copies by tomorrow.
Lordship. May I please, Your Lordship? The petitioner here in Your Lordship, 4 in numbers, Your Lordship, are aggrieved by an action of the revenue authorities, Your Lordship, in trying to dispose them from their Patta land. Patta land. What has happened here, Your Lordship? If Your Lordship comes straight to page 42, Your Lordship. Page 42, there is a trace map, Your Lordship will find, Your Lordship.
Yes.
Your Lordship, this 333 drag, this is a government land. Now, private respondents, Your Lordship, while developing a road, Your Lordship, towards their land, Your Lordship, also encroach the land belonging
But you have preferred the title.
Yes, Your Lordship. Title suit is pending, Your Lordship. Injunction here, petition will be, Your Lordship. Mistake case will be heard, Your Lordship. In the meanwhile, Your Lordship, to preempt everything, Your Lordship, the government, Your Lordship, without any proper demarcation is trying to dispose me. Your Lordship will kindly see tomorrow, Your Lordship, once I am disposed, Your Lordship, there will be, Your Lordship, there will be no, Your Lordship, injunction order in favor of me in that, and that too ensure that, Your Lordship, they have done it. Your Lordship will kindly see once they have undertaken a process.
If you have not been favored with an order of injunction, you have remedies in law.
No, Your Lordship, that is different, Your Lordship. But Your Lordship, what they are saying, you're doing.
But you have made private respondents here. They are your adversaries in this right suit.
Lordship, I have made them
But
parties.
you have not got in the civil case. Not get it.
No, Your Lordship.
You will get if you come in the order. This is a different, the parallel proceeding. We are not entertaining.
No, Your Lordship will kindly see, Your Lordship, while that has been going on, Your Lordship, government is not a party in that suit, Your Lordship. Now, government, Your Lordship, what the circle officer is doing, Your Lordship, they have come, Your Lordship, and trying to dispose us, Your Lordship, by issuing a notice, Your Lordship. That's what, Your Lordship, we are putting, challenging.
Can be challenge the proper remedy would be to file a separate suit.
Because your lordship,
If
ultimately, your
you
lordship,
think that the Patra land,
yes,
and
your
once
lordship,
it is already pending with the private respondent,
that I have mentioned.
why
Your
should we entertain a writ petition?
No, your lordship, because there,
Not only Martin, proceeding, this will be a different ball game altogether.
but your
You
lordship,
said that I am protected by writ court. What will the
no, your lordship, that will not, your lordship. What I need, your lordship, feel your lordship, this
Let
particular.
us see the area of the writ court, the plot, the schedule in the in the plain.
Lordship, the trace map I have annexed, your lordship.
Plain.
Plain,
the
your lordship,
schedule?
I have not annexed, only the
What is the schedule?
lordship.
And what is the schedule of this area?
I have made a clear statement, your lordship, same, your lordship.
Then?
No, your lordship will kindly see, your lordship, my predicament, your lordship will see. Your lordship will kindly see that there is an attempt by the private respondent, your lordship. I filed a suit, your lordship, and suit is pending and injunction hearing will be taken.
When was the suit?
On 16th, your lordship.
Mr. Pottakur, you know the law.
Lordship.
If notice is issued on an ad interim injunction prayer, it amounts to rejection of an ad interim prayer. Your interim injunction can be granted after appearance of the parties, but issuance of notice and not granting an ad interim amounts to rejection. If you are rejected, you can file an appeal.
No, your lordship will kindly see, that I am aggrieved by an action of the circle officer, your lordship. They have, your lordship, they have right, your lordship, unless they, by following due process, your lordship, demarcate the land and then disposes us, your lordship, I don't have anything to say. But your lordship, they have not followed that procedure, your lordship.
Why this issue which you are trying to raise now?
Lordship.
Can these issues be raised, or it might have been raised in the title suit?
No, your lordship, after filing of the title suit, this has come, your lordship. Your lordship will kindly see. I have specifically informed them, the authorities, that the title suit is pending. Your lordship will kindly see 2 or 3 documents, then thereafter your lordship will decide, your lordship.
Will not like to impress upon the jurisdiction of the planet court.
No, your lordship,
if you have come up with the first April, it might have said something.
No, your lordship will kindly see, your lordship, tomorrow, your lordship, if I am, your lordship, dispossessed. Now that will be a ground, your lordship, for rejection of my injunction, your lordship.
You have remedies in law.
But your lordship,
can you preempt the court?
No, they have
preempt the court by coming to the High Court.
They have preempt the court, your lordship. That's just to.
They have the right.
Your lordship will kindly see.
You file another injunction petition.
Your lordship.
That this is what is happening.
It is an action of the government, your lordship. That's why. And government is not the party there, your lordship.
How can you come parallelly? These are the same cause of action.
No, that is not this.
Civil court has all the powers.
No, your lordship will kindly see. This is not the same cause of action in my humble submission, your lordship. This is because, your lordship, I have, your lordship, filed a suit against the private respondents, your lordship, against, your lordship, encroachment of my land.
We have grave doubts to notice it.
Your lordship will kindly see 2 documents.
Will not pass any
no, your lordship will kindly see 2 documents,
if
your lordship.
Convince the court that notice has been issued. Something that's a different matter.
Lordship will kindly see, your lordship, your lordship, a demarcation exercise has been carried out, but your lordship, they have, your lordship, they did not, your lordship, demarcate the land at my prayer, your lordship. And your lordship, when your lordship, that demarcation.
When is the next date?
Your lordship, on 16th, your lordship, hearing, it is fixed for further hearing.
Yes.
4/12, your lordship.
Yesterday, the hearing was.
Yesterday, 4/12, your lordship, for further hearing. 4/12 for further hearing.
For petition. Petitioners. The petitioners claim to be the owners and recorded possessors of plots of agricultural land covered by DAG number 250, 312, 321, /556, 339, /554, 521, 249 of KP Pattanam 86, 115, 161, 57, and 30. Treatment in Revenue Village, Bogibar, Athar, under the Moza, Sonapur, Kamrup, Winnipeg, and the petitioners have instituted a title suit against private respondent with regard to the aforesaid plot of land, alleging attempt and proof. In the case of the petition, that without there being any proper demand, the petitioners are thought to be evicted from their plots of land, in which case the attitude itself may be rendered infractory. That notice be issued, return a next date is what?
On 4/12, my lord.
On 11/12/2020. Yes, who is accepting notice? Revenue? MSPR sending on the Revenue Department accept notice on behalf of restaurant number 1.
Item for 2 and
As
3.
As Burwan, let us take count. Accept for 2 and
3.
2 and let's talk of the consent of for the response by tomorrow. That have to be taken for service of upon the response number 4/02/11 by registered postage 7 by month. That what have placed for an entity model. This court has been appraised that the injunction was heard on 16/11/2020 and the next is fixed on 4/12
For further hearing.
2020 for further hearing. Though this court is not trying to pass a blanket model to balance the equity of the respective party direct that till the next date fixed by the Senate court below, that is 4/12/2020. Status with regard to land be maintained. Is however made clear that the efforts or order should not be taken, should not come the way of adjudication of the sanction of the petitioner by the learned court, which has been done strictly according to its own merit.
Lord, deeply obliged.
This is a lot. Lordship, we have challenged the speaking order dated 21/6/2023, which was passed pursuant to directions issued by this honorable court on an earlier round of litigation, Lord. The basic grounds of challenge are that my patta land, Lordship, of 20 bighas, it was initially in the map for extension of the national highway. So that your Lordship will find at page 53.
Yes.
So that
This order is of 21/6.
21/6.
What's the stage now?
No, Lordship, there is nothing has been happened. We have preferred a representation on 24/8. One plot of land has been shown as mine also and belonging to the forest department.
I'll take the instruction, my lord, whether the for joint verification, my lord, whether Tala has written to the my lord, can I say digital or not?
We'll
my
issue a
lord?
short notice,
My
we'll give a
lord,
date.
lordship will look into the before that, my lord, lordship will look into my lord that page 7.
7.
Page 7.
Yes.
My lord, notice, my lord, to the respond number 1 cannot be issued like that way, my lord. State of Assam represented by the Secretary to the Government of Assam, Karbi Anglong Autonomous Council. We cannot appoint, my lord, Karbi Anglong Autonomous Council.
Yes, Mr.
Cannot
Chaudhary,
represent, my
what
lord.
is-
And the third, my lord, fourth is also, my lord, page 8, paragraph 5, my lord. The ministry also cannot be represented by general manager. Earlier in other courts, my lord, as a ministry only can be, my lord, represented by the secretary,
Secretary.
not by the general manager or the NSA district, my lord. This is required to be, my lord,
If
rectified.
required, Lordship will file an IA and like
Not if required. Where is the question of if? This is the wrong carrying of parties. This is a good ground for dismissing this petition. This is how you make parties in a writ petition.
I'm very sorry for that, Lord.
Here was some represented by Principal Secretary Karbi Anglong. What is this
No, Lordship.
understanding of law?
There was a typing error, I guess, Lordship. I'm very
And
sorry.
what about
Deeply sorry.
that's 1/5?
This was something, Lordship, I should have verified before filing, Lordship. I should not have left it.
You filed an additional affidavit.
Yes, Lordship, I'll file an additional affidavit.
You will consider
doing the,
file an IA.
Lordship, I'll file an IA for correction of the press.
MP Chaudhary, Senate Council. This has granted a week time to file I for correction of the name of certain respondents.
Yes, Lordship, the same order will be in the next case also, Lordship.
But against the mistake.
Yes, I think it will be the same mistake, Lordship, because the issues are highly obliged.
My lord. Lordship, this is an acquisition, land acquisition matters. Lordship, that the predecessors of the petitioner was the absolute owner, which have been the land which have been acquired by the airport authority. Your Honor, Lordship, during the lifetime of the predecessors and even at the present petitioner, never transferred the ownership of the which have been the land acquired.
Where is the order?
Order, Lordship, it is the Annexure 7. It is the page 43, 45, Lordship.
Yes, the order.
And decision order, Lordship, passed by the additional district commissioner on an objection filed by one of the petitioner.
Yes,
Yes, Lordship, here only the ground of rejection of my petition, that is the objection application is that I have not muted my name in the revenue record. Lordship, this is my father's property. So mutation doesn't matter, Lordship. So my right is always there. It is a pre-existing right, came into exist after my father. So Lordship, that is only the ground to reject my objection petition. So Lordship, the
But
notice,
your brothers have sold this land to Minar.
Lordship, it is the question. They never sold it out. They never sold it out.
Are your brothers
Without-
with you?
Yes,
Are they
yes.
petitioners?
Yes, sir.
Who are your brothers?
Brothers are not petitioners.
Yeah.
Only the last, that is the objection, who is rejected by the additional district commissioner. That is the one of the petitioner. That is,
You are Mr. Kolita.
yes,
Mr. Kolita, see, you may be right in contending that mutation per se may not be necessary to establish your right. Your right comes from inheritance.
Yes.
Isn't it? That is your contention. There is no problem with that contention. But here it appears that after the death of your father,
yes, sir.
your brothers have sold the land to a third party. That sale is not the subject matter of challenge number 1. Your right, whatever was there, got extinguished on the sale, being finalized. That is not the part of any challenge.
It is the government reflect that there is no deed number. There is no deed.
Those would be matters of challenge if you have challenge the sale. That you are you had legitimate right over the plot of land. You are a daughter. Your consent was not taken. Challenge the sale.
Lordship, this is the land belong to the 3 original patterners
That is Lokpiram Kolita, Madhuram Kolita, and the Kameswar Kolita. So numbers of legal heirs there. Yeah, out of that,
We don't find any palpable error in this order. Said that the last paragraph, since the land in question has already been sold by by the objector's brothers, the pretext that her name was not included in inheritance cannot negate the authenticity of the sale. So the award is for the plot of land. You can challenge sale.
Lordship, the Kameshwar Kolita, he has left 8 numbers of legal heirs. There are 3 sisters and 4 brothers. 4 brothers. The 2 or 3 of them shown to be sold to.
When was the sale date? Which date? Minar Ali purchased this land on which date? What is the date of the registered sale date?
There is no deed number, Lordships. There is no deed number in the
What is the
commentary.
date of the registered sale date?
Is the only Lordship Annexure 1.
I don't think this is your correct approach. You have to challenge the sale.
Lordship, only we have came to know about the existence of, that is mutation of this mineral and others, that is respondent number 5 to 16. Only when land is acquired, only then we came to know about this development. Prior to not, because we supposed to get the notice of the acquisition. Instead, it was served upon the
Mr.
respondent
Kulita,
number
the
5 to
land was
16.
already transferred to some third party by registered sale date. The validity of the sale date is not even questioned.
Lordship, it is
Now the presumption is in favor of the date. It's a registered sale date. You can very well challenge it.
Lordship, it is sale date. There is no deed number. Although they have shown, although they have,
can you raise the issue of a sale deed in a writ petition? Number one.
although they have shown the registered date, but validity of the registered date is questionable, Lordship.
You question it.
Yes. So, Lordship, it is a
Questionable or not, do you have to question it in the appropriate forum?
Lordship, it is a question of, it is Lordship, it is the dispute in terms of the apportionment, Lordship. So, as
Mr. Kolita, when you are not even the owner or even having any right, title, and interest over the plot of land, it has gone to a third party by a registered sale deed.
Lordship,
You
it is-
challenge the sale
it
deed.
is my father's property, Lordship. So my right is always there, even if no mutation there.
Your right got extinguished by the sale. The transfer, whatever was right was there, it has been transferred to a third party. You challenge the transfer. How can you challenge in the writ petition? Can you go into the legality of a sale deed, wherein the question of evidence would be necessary? You will not get anything in this, Mr. Kolita. We can issue notice. Third, Kolita, the counsel for petitioner who is aggrieved, petitioners who are aggrieved by an order dated 28. What is the date?
The 17/10/23,
17/10/2023 passed by the
additional
district commissioner
insert L prime.
within bracket M, by which the objection of the petitioners, not of the petitioner, of the petitioner number 3
Yes, sir.
has been rejected. Put up. The learned additional district commissioner has observed that the objection with regard to apportionment of the compensation for land acquisition cannot be entertained as much as the plot of land in question was transferred to a third party by a registered sale deed by the brothers of the petitioner number 3. The record, the record does not reveal that any steps have been taken by the petitioner for challenge the registered field in the appropriate forum of law. See the resident that notice the issue returnable by 4 weeks. The Revenue Department, MSPR, Month Standing Council Revenue Department accept notice on behalf of number 1. Whereas MSS Burwal, the State Council
2, 3, and 4.
accept notice on behalf of 2, 3, and Para. That extra copies of the served upon the learned council by tomorrow. That step for service of notice upon the response number 5 to tier 2, 16 be taken by registered post daily. Step by Monday.
Lordship, there is an interim. If the payment is released, Lordship, in course of
He'll
time.
get back. The sale deed has to be first declared illegal.
Okay.
Mr. Sharma?
My lord, this is a very peculiar case, my lord. What happened, my lord? The petitioner took a loan for construction of a godown hall in way back in 2008. And construction completed, then the cyclone damaged not only my godown, even Panchayat office and other offices also and houses. And in the meantime, his father went ill, my lord, of this lung cancer. He died in 2017. But in the meantime, my lord, the DRT judgment came against me and the land was said to have been auctioned in 2017 itself. Then my proposal for
Mr. Sharma, DRT matter, there is a decree, the certificate, you know our respect.
yes, I know. My only mind that what happened in 2020.
We'll do one. You serve this SBI personally.
Okay.
We'll take this matter on Tuesday or Wednesday.
Wednesday.
But you also try to the council. They do not have any standing council.
Yes.
But you can try Mr. M. Sharma is there.
M. Sharma.
M. Sharma. Or you can serve direct. Will pass an order.
Yes.
In their presence, perhaps if something. Otherwise, you are not.
Yes, that I know.
Third, the arbitration order standing council for the petition. Who has approved this court. With regard DRT, with regard to a proceeding for DRT 1, in which a certificate has been issued, followed by e-auction notice. This court is of this court of the opinion that in view of restrictions of rate court to enter in such matters, the concerned bank, namely State Bank of India, be served personally before asking any order. The Parent Council, what's your name?
Yes, sir.
The petitioner is according given liberty to serve the SBI at its address given while describing the response number 1. You can serve the Guwahati of
Got it. There is the office dealing with.
The bank may according be represented on the next certificate, which is Wednesday next.
Yes.
You,
And my lord, after serving the notice by Monday, my lord, I will file a affidavit to their effect.
you can, the petitioner may file an affidavit in proof of such personal. You take a copy of the order, this order, and serve along with.
May it please your lordship. The petitioner is aggrieved by the letter dated 7/10/2020 issued by the circle officer before the additional district commissioner, Vishwanath lordship. Page 34 annexure A. Can I go through it, lordship?
Please.
To the additional district commissioner, competent authority officer Vishwanath, in connection with APR for compensation against acquisition of land of the respondent number 5 for 4-lane national highway. Sir, I have the honor to state that compensation of rupees 13 lakhs and rupees 16 lakhs totaling to rupees 29 lakhs was sanctioned in additional third phase in the name of Sri Lakheshwar Soikia for 2 houses which were left out during the acquisition of land measuring 0.040 hectare covered by DAG number 579 under Miadipatta number 8 of village so-and-so for the national highway number 15. But co-partner Sri Dimbeswar Soikia, that is the petitioner, brother of the beneficiary, submitted objection against the section of the compensation. On the basis of their objection, a hearing was conducted in this office on 4/10/2023. During the hearing, Sri Lakheshwar Soikia, that is the respondent number 5, submitted certificate of local people and Gaon Pradhan to prove that he himself constructed the house, lordship. That was submitted by the respondent number 5, lordship. Now, lordship.
Yes, where is the national? Where is the act?
Lordship.
Act, lord. The acquisition is under which act?
National Highway Act, lordship. My simple contention is, lordship, in this regard, we have submitted 2 representations before the respondent number 2, lordship. That may be considered and disposed of, lordship.
Who is respondent number?
And Deputy Commissioner Vishwanath.
Is it the competent or?
Yes, lordship. It is the competent. It is
adjudicate.
Lordship, because they have fixed the date for hearing it. That is, can you page 44, lordship?
Yeah. What about 3G? 3G.
Whether right of user of any
In
right.
this case, it is the competent authority, lordship. Can you flip page 44?
Has the competent taken? No.
No, lordship.
They have fixed the date for hearing.
So what's the problem?
Lordship, they have fixed the date of hearing on 12/10, lordship, but the hearing was not conducted at that time. Lordship, problem is that the amount has been sanctioned, lordship. If it be released, lordship, then the petitioner will be prejudiced.
When is the next?
Lordship, 1910 is over, lordship. Next day not fixed, lordship. Next day not fixed. We have submitted 2 representations, lordship.
No, if the amount is yet to be determined, then why? How will it be released?
The amount already determined, lordship.
No, if the amount determined by the competent authority is not accepted by this, subsection 5 will come at a later stage when it will be then be arbitrated. But prior to that, the determination are the persons who are entitled to the has to be determined by the competent authority. That is the pending subject matter. Take this process Wednesday next year. Wednesday. voter found for petition. The petitioner is a co-partner. Petitioner claims to be a co-partner of a plot of land measuring 0.040 hectares under Dag number 579 of periodic patta number of PP patta, not PP, of PP patta number.
Periodic patta.
PP patta,
Periodic patta is
PP patta,
oh Lord, so PP number. It should be PP number.
the PP patta number, periodic patta number 8 of HUKAJN, Bukan, Gaon, Brahmajan Muda, under the Helem Avenue Circle, the district of Kana. In the case of the petition, that do the compensation in assessment, the same is sanctioned in the name of the respondent by the private sector. The application of the petition regard was fixed for hearing on 19th, which however has not been done. And Kusam State Council
2, 3, and 4.
State Council raised for some time to obtain and Kusam as well as and portal and state for some time to obtain this promotion on Friday night,
24.
Lordship, it should be 12-10.
not 10,
Oh, 19-10, Lord.
Sorry, 12.
We'll have it on next Friday
Lord.
for motion. To give extra copy.
Lord.
To facilitate the learned counsel for the respondent to obtain instruction from that extra copies of the report bestowed upon them by tomorrow. Will come up.
Apply.
Kindly within my order. 13-10-23.
13th,
Yes, 13-10-23.
16th,
16 and 13-10 before that 13-10.
for bench.
It's up to your lordship. I don't have any. I am ready
No,
to.
see, we don't have any objection. In fact, it's not required to be.
Yes, my
listed,
lord.
but
Yes, my lord.
since
Yes.
something has been expressed by a court and bench, let it.
Yes, my lord. It's up.
Otherwise, anyone can.
Yes, my lord.
In fact, last time it was listed.
Yes. My only contention is that your lordship may fix a spot date, my lord,
Yes,
because
sir.
otherwise,
No, we'll request the registry. We'll not fix a date. But then the convenience of the court,
yes, my lord. Yes.
not proper on our part. This court has spoken that by order, the matter was directed for honorable judge who had passed the court on for this court
Oblige.
Oblige me.
May I please, Lordship? This IA is filed for vacating of the interim order. That is, your Lordship will find the interim order is at page 28. Operative part is at page 33.
Who's for the other side?
I'm
Ready for the matter?
yes, your Lordship. Page 20. Well, against the no confidence motion,
Who is the petition?
petitioner-
Rahima Khan.
yes, Rahima Khatun, he is the president.
Not he.
She is the president of the government.
What the government?
Gaon Panchayat name lordship, that is
Halotson Noya Gaon.
15, number 15, Jalosar, Noyaga Gaon. In the district of Sat.
You are the president.
No, he is the writ petitioner.
Who are you?
My lord, we are the member.
How many of you are?
My lord, we are six.
What is the majority required?
Seven already casted vote.
No, now here in this.
My lord.
Why not 7?
No, all sevens are there.
No, you are
I am representing the respondent number lordship.
6 of them.
Yes.
One has already gone towards this side.
No, 7 already casted vote in favor of.
That was at the time of casting vote.
My lord.
During proceeding.
But one perhaps lordship has not been made part.
You said 7 has been made part.
No, 6 has already been made party, but 1 has not.
Why haven't made?
My lord, only vice president was not made, is not
Yes.
made party in.
But the vice president has casted his vote.
Yes.
My lord. But other man already party. My lord.
No,
And-
person who has casted a vote, why he is not a part?
My lord, since my lord, in earlier occasion, my lord, proceeding was drawn under 15-5, my lord, both the president and the vice president. And the my lord,
Okay, that
resolution-
doesn't matter. You are for 6 of the
My lord.
members.
My-
Yes.
My lord, page
Where is the interim order?
my lord, page 28, operative person is at page 32.
Yes.
Basically, lordship, the writ petitioner has been instituted on
The
program.
at 32.
Two.
Order dated
My lord,
29/9.
29.
Please read.
My lord, second paragraph. The petitioner is assailing the convention of the special meeting to be held on 30/9/2023 so as to discuss the no confidence motion brought against the president of number 15 number Jalosar Noyaga Gaon Panchayat. That is the writ petition.
Yes.
The primary point raised by the petitioner counsel is pertaining to the disqualification incurred by 2 of the 8 members of the Gaon Panchayat on account of having more than 2 living children, thereby invalidating the requisition itself. This is a legal issue which would require deeper consideration before the court can take a decision on the prayer of the interim relief made by the petitioner. Therefore, in order to give an opportunity to the learned departmental counsel to examine the issue and address the argument, this writ petition is directed to be posted again on so for motion as fixed item. In the meantime, it is provided the meeting as convened on so may be held, but the resolution, if any, adopted in the meeting shall not be given effect to till the next date.
Did you hold the meeting?
Already meeting held, and out of 7 member lordship, all the 7 member lordship has casted vote in favor of the no confidence vote. But the resolution has not been given effect because of this interim order.
No confidence passed.
My lord, pass. Okay. So far, this disqualification of 2 members are concerned, lordship.
Yes.
These 2 members did not participate in the proceeding as they have already resigned their members. I have annexed the document also, page 33 and 34.
They were not in the purview of this no confidence. They were outside.
They are outside.
Yes, your lordship, because they have, my lord, more than 2 children. Yes.
So if they are out, but 7 who are credit voters.
My lord, regarding the majority, I have no question, my lord, they have majority. Here question is raised, my lord, regarding the proceeding. My lord, the proceeding issued, my lord, not in a proper manner as per section 15 of the, my lord, Panchayat Act, my lord. Because, my lord, section 15(2), my lord, the requisition to the president is mandatory, my lord. In earlier occasion, my lord, and it is, my lord.
What is your ground? What was your ground of principal ground?
My principal ground is, my lord, the executive officer issued the impugned notice, my lord. My lord, he has no authority to impugn the issue notice, my lord. Because my lord. Impugn notice is page 45, my lord,
of the petition.
of the writ petition, my lord. Page 45.
Yes.
May I read, my lord?
Yes. What are your grounds of that?
My lord, kindly see the, my lord, section 15.5, my lord. But notice was issued under section 15.5, my lord. Basically, my lord, I am starting from second paragraph, my lord. In the case of the, in case the president, my lord. 15.5, second paragraph, my lord. In case the president of the concerned Anchalik Panchayat does not take action as above, the secretary of the Gram Panchayat within 3 days after the expiry of the stipulated 15 days time shall refer the matter to the concerned deputy commissioner or the subdivisional officer C, as the case may be. On receipt of the information, the deputy commissioner or the subdivisional officer, as the case may be, shall convene the meeting in the information with the intimation to the mallet concerned Anchalik Panchayat and Jila Parishad and preside over the meeting. Proviso, my lord, that is important, my lord. Provided that the concerned deputy commissioner or the subdivisional officer, as the case may be, in case of his inability to preside over the meeting, may depute a gazette officer not below the rank of class 1 gazette officer to preside over the meeting. My lord, deputy commissioner shall convene the meeting as per the, my lord, act. He has no power to depute the meeting officer to convene the meeting, my lord. My lord, gazetted officer can only, my lord, when the deputy commissioner is unable to preside over the meeting. This is, my lord, clear. My lord, kindly see, my lord, section, my lord, 138, my lord. This is, my lord, my friend, my lord, earlier office page.
Section 130.
138, my lord. 138, 2, my lord. Regarding delegation of power.
Yes.
My lord, delegation of powers to the deputy commissioner, subdivision commissioner, or any other gazetted officer, my lord. I am referring 32, my lord. Except where expressly provided to the contrary, the government may delegate all or any of the powers of the deputy commissioner or a subdivisional officer under this act or rule framed thereunder this act to any government officer of gazetted rank, my lord. My lord, 138 2 provides, my lord, where there is no specifically mentioned, my lord. In that case, my lord, the deputy commissioner, my lord, delegate his power. Here, my lord, section 15.2, my lord, there is a specifically mentioned that deputy commissioner or SDO civil, as the case may be, shall convene the meeting. Not he has the power to delegate to convene the meeting to other officer subordinate to him, my lord. Only, my lord, he can delegate his capacity when he has inability to preside over the meeting. So, my lord, as per section 52, my lord, this case is, my lord, the impugn notice is, my lord, is beyond the capacity of the, my lord, deputy commissioner as well as the, my lord, the chief executive officer. And the, my lord, regarding the, my lord, 15.1 and 2, my lord.
Yes.
My lord, 15.1, my lord, every president, my every president or vice president shall deem to have vacated his office forthwith when resolution expressing want of confidence in him is passed by a majority of 2/3 of the total number of members of the Gram Panchayat. Such a meeting shall be especially convened by the Secretary of the Gram Panchayat with the approval of the President of the Gram Panchayat. Such meeting shall be presided over by the President if the motion is against the President, and by the Vice President if the motion is against the President. In case such a meeting is not convened within a period of 15 days from the date of receipt. My lord.
130 is with regard to delegation of powers by the government.
My lord.
It is not delegation of powers by the Deputy Commissioner to the SDO or by the SDO to any gazetted officer.
My lord.
It is the powers of the government vested by this act to be delegated to certain officers, which is provided in the miscellaneous chapter of one of this act.
My lord.
The miscellaneous chapter starts from which paragraph? This chapter 11, 115.
Well,
starts from 115. It's a part of the miscellaneous chapter. Only to remove any difficulties and for smooth operation of this act. And one such of the provision is 138, where the government can delegate its power.
My lord.
This power is not exercised by the government.
My lord.
This exercise of convening the meeting is vested with the Deputy Commissioner or the SDO.
My lord.
15.5 is that in case of his inability, he may do it through some gazetted officer of class.
Well,
now this notice which has been issued, are you questioning the competence of the authority?
Yes, your lordship.
Under what provision?
My lord, under my lord, 15.5, my lord.
15.5 makes it very clear, proviso, that the concerned Deputy Commissioner or SDO, as the case may be, in case of his inability to decide over the meeting, may appeal. It's a prerogative when the DC or the SDO.
My lord, prior portion, my lord, that my lord, his my lord, delegation of power to my lord convene the meeting, my lord.
Yes.
So, my lord, that can be my lord, cannot be my lord. Because if to convene a meeting, it is only the power of the Deputy Commissioner or the SDO.
Then what is the meaning
Not
of
he
the
has the
proviso?
power to my lord.
What is the meaning of this proviso? In a given case, the Deputy Commissioner may have several other duties.
My lord.
He can get it done.
Well, that's why the presiding, in respect of presiding the meeting, my lord, it was relaxed that if he engaged some other work, that my lord, he cannot be, he need not be to my lord appear in the my lord meeting. But regarding my lord convene a meeting, my lord, it is the, my lord.
Yes, 45.
Yes, 45, my lord. Yes, 45, my lord.
Before that, my friend.
45.
Page 45, my lord. And my lord, till date, my lord, the authority has not, my lord, produced the report also, my lord.
See, it's the very static line.
My lord.
I see so ACS, so on being authorized.
My lord. My lord, that is not mentioned under what authority, my lord. He has, my lord, delegated his
That
power,
we may examine, but that would not be a cause to stay a democratic process. Where 7% are against you, can you force yourself to be seated in the office?
My lord,
members do not like you.
My lord, can we taken it on Monday or
no,
my lord? My lord, kindly speak. My lord.
You have the record, Mr. What is the instruction?
On the law point, I can submit.
You will hear it.
My lord, kindly see, my lord, the order dated, my lord, earlier, my lord, order, my lord, petition page number 31, my lord.
Okay.
My lord. And the same order is also annexed in the IA also, my lord.
What is the order?
My lord, in the read petition, my lord, page, my lord,
the interim order.
Earlier round of litigation order, my lord. Page 31, my lord. Page 31.
Yes.
My lord,
earlier it was set aside.
Earlier, occasion, my lord, video, the block development officer was issued the, my lord, notification, and that notification was challenged by both the, my lord, president as well as vice president separately because it was under the, my lord, section 15.5. when section 15.5, my lord, requisition, my lord, is not required to serve, my lord, to the petitioner. So, my lord, it was challenged only on the ground of, my lord, that the block development officer has no power to issue such notice, my lord. My
Where
lord,
is that notice? Where is that notice?
my lord, I have an
Earlier notice?
my lord, the page 28,
20.
28, my lord.
8.
28, my lord.
Has got no reference to any other. Perhaps on this reason it was prepared. You read this?
Yes.
As per section 515 of the Act, it's a acquisition. He simply calls for the meeting.
My lord, I am referring to this judgment only because, my lord, the section 15.5 is not, my lord, attracted because prior to section 15.5, my lord, it has already done. And my lord, earlier resolution was taken against the vice president, that is still remain, not aside. And regarding the resolution taken against the president, my lord, it was set aside, my lord. So, my lord, when, my lord, one resolution is still remain, another set aside, my lord.
When did the tenure start?
My lord, tenure start from 13/12/2018.
18.
18 now going to retire, expired in the month of December.
Oh, my lord.
Only few days.
Only few days.
Last month, 30.
Right.
For some collection, though.
No, my lord.
Not collection.
No.
Where are you interested for 1 month?
No, my lord, there is a procedural left, my lord. My lord, kindly see, my lord.
Why did you
at
pass
least
a resolution at the end of the fag end of the career?
My lord, since the
My lord,
You
petition,
could have waited for 1 more month.
My lord, we are fighting
You
for,
would have honorably vacated the office. Now you're forcing him to vacate the office.
we are trying to remove her lordship from the month of lordship July.
my lord, the petitioner, my lord, directly elected, so there is some procedure to remove, my lord. But here in this case, my lord, they have not followed, my lord. The remove.
Third,
My lord, one thing lordship, just one
you don't want the stay to be vacated.
lordship.
You want the stay not to be vacated to make your argument.
Obliged.
Third, step on the concept for the applicants who have filed application for modification of the vacation of the interim order dated 29/9/2020 passed connected step 5778 of 20. Also heard the M. Islam when it counsel for opposite party number
6. The IA, my lord.
who is the representation of the as of the Planet Health Council. PNR department is present as well as and Booster Planet State. The opposite party number 6, who is the writ petitioner, has put to challenge
Yes, 45. In the repetition.
32.
The 32 is the interim order.
Has put to challenge the convention of a station meeting which was held on 39/20 on the subject of no conflict against her who was president of number 15, Dhalor Char,
Allowed, sir.
Naya Gaon, government had in district of South Salmara, Manpachar. The contention of the petition, writ petition, that two of the 8 members of the government were disqualified by operation of law, and therefore the meeting should not be allowed to convene. This court, by the order 29 while giving opportunity to the department, to the learned council of the department to obtain drugs, had posted the matter on the next day and also observed that if any resolution is adopted in meeting be held on 39, the same shall not be in effect till the next day. The aforesaid report was executed on the next day. The Senate Council for the have submitted that the principal ground which was projected will not have any relevance at all, in as much as the 2 members whose membership may be affected by operation of law had already resigned, and the no confidence motion was duly passed by 7 members whose membership was not subject of any. He further submits that there is no ground at all for maintaining the present challenge, and in the meeting held on 39 the no confidence was duly passed, which may be given effect as the act in question prescribes such a mode of removing by a no confidence motion. Per contrast, Senate Council for the opposite person 6 as petition has submitted that procedure adapted itself by referring to the impugned notification date where is the page
26/9/2020
page
45 last.
dated 26/9/2023 is submitted that the chief executive officer does not have jurisdiction to convene such a meeting, and such powers are only vested with the deputy commissioner or the sub-divisional officer as the case. By referring to section 5, is submitted by Spectrum that though he provides to people that a gazetted officer not below the rank of class 1 may be deputed to preside over the meeting, comma, the meeting has to be convened by the deputy commissioner or DS as per the same section. By referring to section 138 bracket 2 of the Act, comma, the registrar of the Learned Council has submitted that the delegation of powers can be made only by the state government, and the same will not protect the impugned order. And the as of the Standing Council of the department has, however, submitted that a bare reading of the impugned notice dated 29/2020 would reveal that the same, though issued by the chief executive officer, comma, the same was done as being authorized by the deputy. Further submit that there is no manner of doubt that the chief executive officer is a gazetted officer not below the rank of class. The private conditions made by the Learned Council for the party have been duly considered. The procedure for passing a no confidence against the president and vice for Gao Panchayat is based on in section 15 of Assam Panchayat Act. Though the preliminary ground, though the primary ground was with regard to disqualification of 2 members by operation of law, comma, the state ground appears to be non-existent as it proves that those 2 members had already resigned and were not among the members who had voted in favor of no confidence. So far as the objection raised on behalf of the petitioner to the prayer for vacation of order by section 15(5) read with section 138 of the Act, this court is of the view that deputation of a gazetted officer not below the rank of class 1 gazetted officer to preside over the meeting cannot be given a narrow meaning, more so when the notice issued in the writ proceeding clearly revealed that the meeting was convened by the chief executive officer of the Jilla Parishad on being authorized by the district from South Salpara, Manpachar district. The proviso to section 15(5) clearly empowers the deputy commissioner or the sub-divisional officer to depute any gazetted officer not below the rank of class 1 gazetted officer to preside over a meeting of no conflict, and the intent is the notice listing such meeting though issued by chief executive officer has been done, has been authorized by the deputy commissioner. This court is also fortified in taking the aforesaid view in this case as there was an earlier proceeding by WPC 4052/2020 instituted by the petition in which the matter was remanded back for holding the meeting of the. The provision of having a no conflict motion being a part of democratic process and is a prescription of the law holding this court is also of the view that when there is a clear mandate against the petition to continue as president of concerned government, this court would loathe and interfere in such matters on mere technical and in the instead case the ground sought to be protected also appears non-existent. In view of the above, order dated
29.
29/9/20, which was extended from time to time. Did petition you like to continue or not?
My lord, continue.
Continue.
With other issues, is only oblige your lordship.
I said of the order. Mr. Pathak, we have recorded your name in a PDCL matter. Yes, what has happened now here?
The petitioner is here against the non-payment.
No, we know what has happened now.
Now the Home and Political Department has filed a very strange affidavit, your lordship. They are saying that yes, though an order was passed by the then state coordinator of the NRC, appointing you as sending counsel, that order is irregular and he could not have passed it. So in effect, he should be made liable to pay the pending dues of the petitioner. Perhaps that cannot be a stand which responsible authority can make, your lordship.
When
Order
was
is
the-
passed.
When was the affidavit filed?
That affidavit was filed on 3rd of May 2023.
Have you filed anything?
Perhaps a response would not be necessary, your lordship. May kindly have a look at the.
No, then we'll hear this man.
Yes, your lord.
Whenever you wish, you can file a response, otherwise we'll hear. How much amount has been paid till?
20 lakhs has been paid.
And how much is pending?
1 crore 40 lakhs is pending. For 3 years, your lordship. That's the entire amount for 3 years.
Yes.
But we have taken the from the LR.
No, we'll have to.
Next,
or you may fix it.
How to keep it for the top. Whereas
one, no, I'm from one lot. NRC is also here the party.
NRC, who's the NRC?
Name has been some lot.
Who appeared? Ownership like RKD চলছে।
He has resigned.
He's not there.
No.
Who is presently owner?
Perhaps after he has resigned, I'm not sure if anybody has been appointed. So
You do one thing, you will correct the name, pass your inform the board. Either.
very well.
Whereas this board has been informed that the earlier test council of energy has resigned.
Yes.
Resigned?
Yes.
So earlier council of energy is no longer
Concord.
Reading are come and the matter is taken up. This for on
What may fix it as per Dr.
the 14th of
Very well.
the name of commissioning of the effect
Perhaps that is already been written.
But his name is
have the name.
Yes.
Try to get the
Yes.
Maybe your Lordship. Lordship, in this matter, the cleanings are complete. The respondent number 1, company had some scrap material. They had some scrap material and they entrusted the respondent number 2 to dispose of the scrap material.
Who's respondent number 2? Mines and minerals.
No, MSCC.
Four.
1, 2, and 3. Respondent number 4. So 1, 2, and 3 had some scrap materials. They
Mineral scrap record. What is it? Sir?
Thereafter, the petitioner, who is a registered buyer under the MSCC, he participated in an auction proceeding. Now, the auction notice, your Lordship, may be produced at page 30. 30.
Yes.
Lordship, here.
Now, what has happened now?
Now, what happened is that once, I'll give the gist before going to the meeting. So what happened, this auction was, he participated in the auction. Morning, he gave a bid. He was supposed to give a bid amount of 20,001.
It was an e-auction.
E-auction. So he was supposed to, in his mind, it was 20,001. He mistakenly wrote it as 2 lakhs 1. 2 lakh 1 rupee. So the bid amount for the total.
And in words,
it is automatically taken. It is not written, entered by us. It's just the number has to be given. So once the number is given, then the pop-up comes wherein you just need to confirm. You're not required to re-enter. So this was the process, and then he entered the thing and he was waiting for the auction. Then as he saw that there was no movement as such, and he left. There was no movement. Around 4:15 he came.
What was the value otherwise notified value?
There was no notified value. There was no base price, reserve price. There was no notified value. Nothing. What is important is that, Your Honor, before the auction was, before he participated in the auction, there is a requirement to deposit a particular amount in a pre-bid wallet. In the pre-bid wallet, he had deposited 34 lakh. So in his mind, he was in the, why is it 34 lakh? Because that is the 10% EMD amount. So in his mind, he had already thought that he'll buy at the most 3 crore worth of product. That was the mind of the petitioner. Now what happened? Thereafter, at 4:30, when he realized this mistake, he immediately wrote a mail.
What was your view? How much did you bid for?
When I entered the amount, in my mind, it was 20,001 rupee for one lot. That was per metric ton.
Total amount was how much?
Total amount, it would come to 27 crores if it is 2 lakhs, and 2 crores 73 lakhs if it is 20,000. So that was
So what thereafter, what happened at 4:30, I wrote a mail immediately. Here, why I wanted to show the auction notice, where the auction says that till 4:30 the auction would go. So once I gave the withdrawal that I withdrew from the auction, then I wrote a mail immediately to the MSCC as well as to coal. Now they rejected my claim that no EMD is forfeited. That is the basic thing. After filing of this case, they filed an additional, they filed a affidavit wherein they re-auction the matter and re-auction the whole scrap, and the auction is done. The whole scrap is now, it's no longer there. The things, whichever it was there, which was that lot, it is auctioned at. So my humble prayer, in this limited case of my humble prayer is that here I had done, when I realized the mistake, I realized the mistake at 4:30. I immediately informed the authorities. I'm paying only for the release of the EMD, which is forfeited.
34,49,000.
Yes.
Yes, madam.
Lordship, as per the auction terms and conditions, Lordship, which your Lordship will find that page number 21, Lordship, of our affidavit in opposition. Lordship.
Yes.
This EMD, Lordship, was the middle portion, number 2, EMD.
Yes.
The fourth line, Lordship. The EMD should be adjusted towards material value only after receipt of the balance material value of the last installment along with applicable duties and taxes, failing which the EMD will stand automatically forfeited. Now, he did not deposit this amount, Lordship.
He did not deposit it.
No. That would amount to 2,73,73,336. As he failed to deposit this amount, the EMD that shall automatically forfeited, Lordship. And it was to his knowledge, Lordship. He ought to have read the terms and conditions carefully.
No, he is not. Your power to forfeit the EMD.
Lordship. No, that is what he is disputing, Lordship.
No, he is not disputing the power. He is saying that
Refund of the EMD,
you can
Lordship.
take a reasonable stand because there was some error in making the deed.
No, that error was there, Lordship. And for his error, Lordship, maybe it was intentional or unintentional. I had to suffer loss, Lordship.
What
That
loss?
materials had to be re-auctioned. And that was
How
a
much
much higher
was
price, Lordship.
How much was the cost involved? CDR.
Lordship, in the next pre-auction, Lordship, it was 4.1 crores, Lordship. The amount that was bid, Lordship, that was the materials that were sold, that was at an amount of 4.1 crores, Lordship.
And how much was he offering?
Lordship, may kindly have a look.
Taking his erroneous bid also, how much was his amount?
2 crores.
2 crores.
Lordship, may kindly have a look at Annexure 4 of my additional affidavit, Lordship.
Now tell us what amount, how much was the loss of the
The loss that we sustained, Lordship,
How much?
4.1 crores. 4.1 crores.
loss?
Lordship.
How?
How much
Lordship,
was the
may
new
kindly have a
bid?
look at my
How much was the new bid? The purchase was how much?
that
was
was
the
same
amount?
proceeds, that would come to
17 crores.
23.27 crores, Lordship. And if we had accepted his bid, Lordship, then the amount would have come to 27.37 crores, Lordship. There was
And
a loss,
you
Lordship.
sold in how much? 20?
23.27 crores, Lordship.
Let us come back. Proceedings have been exchanged otherwise.
Yes, everything.
Okay, we'll hear this then.
Lordship, it was already fixed for hearing. It had come around 3-4 times, and then again I came in admission stage. I don't know how.
We'll have it on admission stage.
Lordship,
On a hearing.
Lordship was very short date maybe given because I'm suffering from
Admission hearing. We'll have fixed it. Hard data. One, two, and three. Anyone for 4?
Four
P. Borua was
she was appearing.
P. Borua.
generally
But MSC.
MS.
Yes.
And
None.
She has also filed her affidavit.
She has also filed a affidavit.
Court has been informed that 4 has also filed it. Pleading and order to this
For hearing, Lordship, because
We'll not this for hearing. This for admission on
Lordship, as early as possible. Next week if possible.
we'll have some 30th of
Okay. Deeply aware.
Thursday. Come prepared, we'll.
I'm-
And
Lordship,
that
can
will
it
come-
be on 5th of December, Lordship, 30th?
5th of-
5th of-
is the- fifth of-
the Misa Army camp. So far as the facts are concerned, Lordship, there is not much of a dispute. Because the competent authority has filed affidavit as well as the National Highway has also filed affidavit. But competent authority has said that yes, they have spent a particular amount for
You are agreed by the quantum.
quantum.
As per you, it should be more.
As per us, it should not be more. Actually, we are not aggrieved by that exactly. We are aggrieved by non-payment of that amount.
It's not been paid.
That has not been paid.
The assessed amount has not been paid.
That has not been paid.
Yes,
The amount was reassessed by the, that building, amount of the building, reassessed by the PWD engineer. How the PWD engineer, he cannot actually reassess the amount. That there should be some joint survey, every.
but why haven't you released? Yes, the state government.
We have already deposited.
Your part perhaps you have, your application is over. Right?
We
You
have
have
already
deposited the amount. Yes, sir.
No, not deposit. Lordship, we have written to them after the award.
Okay.
So
But they have not-
arbitrator, they have not approached the arbitrator. The first remedy notice they have got after the first their assessment. Arbitrator.
No.
Arbitrator दिया ना. They have not approached the arbitrator.
I'm sorry. That
That
was
was
reassessed by
reassessed by the
executive
lordship. I
engineer.
have annexed.
Have you received anything, Mr. Chaudhary?
Yes. We have received
One portion you have
we have-
received.
a portion we have received.
The reassessed amount you have not.
Yeah, the reassessment which was done before this payment was done. And in that reassessment, it is written in the record that the earlier assessment is cancelled. So now, Lordship,
But the amount which you have received, this is commensurate to the earlier assessment amount.
it is same.
Okay, that means the reassessment part they have not taken.
They have not taken.
Lordship, I have filed affidavit.
And we'll hear this matter. How much is the difference now?
Now, difference according to us, the Lordship, in total, they have paid about 30 lakhs.
Now
But
the reassessed part.
according to us, after reassess, not only as per us, as per the executive engineer in the
That is it.
computer,
What
this about 33 lakhs should be the valuation of the property. And above that, there will be solatium, there will be multiplication of factor, that is 2. So all these as per the Fair Compensation Act, by use of the Schedule 1. So all those will be, it will be more.
If they are not satisfied with the amount, Lordship, they have already received the amount. After that, they have now raised objection.
No, we have raised objection before.
No, no, but this contention would have been different if they were aggrieved by the adequacy of the amount. Now, what
Yes.
Mr. Chaudhary has contended, what we have understood, that the amount was reassessed. Whether that reassessment is in accordance with law, that's a different matter. He can raise that issue
Yes.
to adjudicate. But he is only aggrieved by the fact that after the reassessment, the amount which will now come be paid to him, that has not been.
Lordship,
Lordship, shortly, I'm making my submission in 1 minute. So far as the NH Council has said that the executive engineer cannot. But in the National Highway Act, it is there that competent authority may take
We'll
help.
hear this matter
Yes.
on a hearing date.
authority has
On
no
a hearing
power.
date. Very soon. Matter of which, just tell us that. What is
I would want it as soon as possible. Lordship will.
tell us. Today is what? Today is 17th. We'll have this on 5th of December. Okay.
All right.
Readings are complete and the matter
Holidays नहीं
taken up for at the
Holiday
readings are complete and it is
Lordship,
the
here
matter can be
I take it.
taken up for
the
disposal.
5th of December.
Lordship for 5th of December.
Lordship, 5th of December is shown as a red mark. It is
It's a restricted hold.
oh, restricted. Okay.
Yeah,
Obliged.
apply.
Yes, may it please your lordship. This matter is very simple here. What has happened? The petitioner has applied for a construction of a building in Jorhat here by the municipal board has given the
Golaghat or Jorhat?
Jorhat. Sorry, Golaghat municipal, Golaghat. The Golaghat municipal board has given the permission to construct the building, everything, 3+3. Now what has happened, some employees of the GMC has interrupted us, the Golaghat municipal board has interrupted us and not allowed to continue with the case. We have thereafter come before your lordship. Lordship, what has happened, the board as well as the concerned persons are made parties here.
Right.
We have, yes, we have we have taken step as well as we have taken Dusty. It was they have received, but they have not come till the last occasion, your lordship. They are not appearing even after receipt of Dusty. That is
That board
record.
commissioner has been made a party.
Yes. Because your lordship, what has happened? These persons have
But
stopped.
you are a resident of Guwahati.
I have a residence in Guwahati, but I am building a house in Golaghat. In this house, your lordship, basically, it's an RCC G+2 commercial cum residential building.
What do you do? Businessman?
I'm a business.
Okay,
And
yes.
this- And in
Affidavit
fact,
file.
Because one FIR
was FIR was
No, respond to
FIR number
R3 has filed affidavit.
R3 is the superintendent. FT.
superintendent of police.
What about your Golaghat municipal?
Golaghat municipal board have taken step and then Dusty, but they are not appeared. Neither they nor these two persons against whom the ward commission, because she was the one who came and stopped the construction.
Then wait, there is already an order of 310 holding the services complete.
Yes.
Can have this for disposal
Yes.
next
But-
week. Next Thursday.
There's nothing much, your lord.
And
Permission has been given.
employees cannot give permission to the CEO.
Permission has been given, your lord.
As agreed to by the parties, this case for a hearing on Thursday night,
Yes,
on which date an endeavor to dispose of.
much of it.
In the meantime, Mr. After try to get some instruction
From the municipal board.
municipal board. BJ Tarpur, Senate Council, appearing for the maintenance of the instruction from competent authority.
Board have no objection. Otherwise, anyway, much of it.
Now what is?
No, I have been staying like that, your lordship. I have not been allowed to construct, so I'm stuck there. So only thing is that
Still
actually I would have
like-
prayed for an interim. Since your lordship is disposing it off next day, that's why I'm not praying. Much of it.
Mr. Chaudhary, there is one matter NRC, you are not going to the NRC council.
I have,
Is there anyone else?
I do not.
If you, for the sake of convenience, to fix the matter in the next,
Just
if
I
you
will
can just
inform.
convey to the NRC authority, if they can at least. They have passed an order to reflect the name of SC NRC,
Yes.
but we are being informed that you are no longer.
They are taking back all.
May I please your lordship? Lordship, the petitioner is a owner of a plot of land measuring 50 less.
Yes, instructions. Instructions.
Earlier occasion notice was issued, my lord.
Yes, on 9/8.
Yes.
Who's appearing? Madam, you're appearing.
Not have any such case. This case, lordship, we have already deposited an amount of rupees 29,20,630 for Jirat and structure.
I have made a representation for reassessment, my lord. Actually,
Reassessment, how can
in-
they have to
You
approve
have
the-
raised, somebody has raised an issue on tentativity of the the state government. On 12/6/2023, when the matter was taken up, on account of the alternative remedy available at the 3G,
3G, 3G5.
and here notice was issued on.
So he can approach the arbitrator lordship for enhancement of form. Not satisfied with that.
You file your affidavit. We will also hear of the preliminary objection, raise it formally.
I have prepared the affidavit after file. Send for getting
admission hearing.
On the prayer of MS R. Bora, Training Council, NHID here,
And I said,
as it is the PJ Training Council, appearing for the state court. Matter is adjourned by 3 weeks to enable filing of statement of
Obliged.
Your Lordship, this is the case under the Land Grabbing Act. What happened is, we are Coal India, we have lands all over Margherita area. A small portion of the same was forcibly occupied by the respondent here. Okay. When we initiated the eviction proceeding, the matter, instead of being heard by the trial court, it was sent to the land grabbing tribunal, okay, which is presently manned by the additional district judge. And in that court, you in that case,
your counsel has some difficulty in attending the tribunal because of some injury.
no, we have no difficulty. What has happened at that time, Your Lordship?
That is it, in the tribunal.
In
So
tribunal.
it was dismissed.
It was dismissed because he was not present.
Madam, we can send it back.
Lordship, in this case, I have filed an objection regarding the maintainability of the case, Lordship, as a writ petition. Because the whole procedure is under the civil procedure code. But this writ petition has been filed asking for issuing charge order. In the
No, no,
case, only
what-
entire matter has been disposed of. When it is entire matter has been disposed of, they must file an appeal or otherwise in the
Appellate forum is it there?
No.
Lordship.
There's no appellate forum. It's yet to be constituted.
There is no appellate forum now, but it should be CRP, not that is decided by so many cases.
That,
by the Honorable
that
Supreme Court.
technical objection will perhaps will not accept.
And only for two orders, they have filed this writ petition, not for entire matter.
We'll demand this back for adjudication on merit.
On merit.
You contest that?
No, we are contesting. It took only for 5 years. This is on this and that plea, Lordship. They have taken.
When was
Taken
it,
time.
when was it instituted? The land grabbing proceeding? When was it?
2018, Lordship.
It will fix a date. Very short time. During that. What is the stage otherwise? Did you adduce evidence?
Only for cross-examination of the.
We had filed evidence on.
Evidence was
Evidence,
filed.
yes.
Cross-examination was done on.
No.
And your evidence?
They did not
Nothing.
appear, Lordship.
Let us see your the order. But if you are neglecting, Mr.
Yes, intentional, Lordship.
No, that is what they say now.
Hey,
Page
you are-
48.
Bid court will see the equities also. If you are neglecting, then you may not pass orders. But let us see that order.
Page 48.
48.
প্রথম order, no?
Annexure 13 road,
Second.
page 48.
Twenty-three, is it 23?
Yes, Lordship.
Please read.
Yes.
Yes. 48. Your Worship, respondent is duly represented by his engaged advocate. Today, this case is fixed for appearance of the petitioner's witnesses to face cross-examination by the respondent and for payment of cost of rupees 10,000 to the respondent as condition precedent. By previous order dated 28/2/23, it was made crystal clear that the petitioner's witnesses shall invariably remain present before the court to face cross-examination by respondent, and no further adjournment on any ground whatsoever shall be allowed. It is worthwhile to note at this juncture that the order dated 28/2/23 was passed in the backdrop of the fact that the petitioner company, through its engaged advocate, had already taken number of adjournments on this or that pretext and had already eaten up substantial time of the court. On 28/2/23, the engaged advocate for the respondent was all along present before the court with all preparation to cross-examine, and he sincerely submitted that he would cross-examine all the witnesses of the petitioner company on that day itself to curb further delay. Yet the petitioner's witnesses refrained from appearance on pretext that they were engaged in some other court to submit their evidence on affidavit. Simply a petition was filed on the said vague ground, and the engaged advocate for the petitioner did not appear before the court even to move the said petition on the ground that he sustained knee injury and was unable to stand up for a long time. This was, the lawyer was not, he was sick for that period. Yet it is also pertinent to mention that on 28.
We have doubts on your conduct, Mr. Ahmed.
Lordship,
we have serious doubts on your conduct. You have been negligent. You have been negligent.
No, the counsel, he was seriously.
Counsel, he in a cross-examination, what is his purpose? It's cross-examination of your witnesses.
No, he is the engaged counsel.
He can have somebody else. He can sit in the court not only one day, continuously is absent.
Yes. Lordship, in the subsequent paragraph, it is mentioned about everything.
We allow this, but we impose cost. You were a company, big company. Cannot treat matters like.
He was present in the other court, Lordship.
No.
No, subsequently, yes, down.
We'll allow this, but we'll impose cost. Hurt. Okay.
26. 26.
For petition. When it comes for the sole respondent.
Yes.
Sole respondent. Please have this. Considering the subject matter involved and nature of the president is taken up with both the admission case. We mentioned that reading have been in the meeting. The petition number 1 is a company which and claims to be lawful owner of a plot of land covered under dark number 304 part and dark number 3128 part of Patta number 1 of Margarita Town near the State Bank of India, Margarita branch. The case of the petition that the respondent had forcefully occupied the state plot and started construction activity from the year 2018. Though FIR was lost and the matter was investigated, there was possibility of breach of peace and therefore a proceeding under section 107 of the 144 of the 145 of the CRP was drawn up. The matter was subsequently transmitted to the special tribunal constituted under Assam Land Grabbing within bracket Prohibition bracket to the Act of 2010 Margarita. Accordingly, the proceeding was initiated and numbered as LD case number 5 of 2018. The petitioners are aggrieved by an order dated 23/3/2020 by which the case instituted by them has been dismissed as uncontested. Sri Ahmed, the learned senior counsel for the petitioners, has submitted that there were reasonable grounds for seeking adjournment on the same date as the contracting counsel was having some health issues and was therefore unable to attend the court. It is further submitted that by dismissal of the case on technical grounds, the petitioners are deprived of an opportunity of the subject being adjudicated on merits. He accordingly submits that the order impugned may be interfered with and the matter be remitted back to the learned tribe for an adjudication on merit. Per contra, MS Dev, the learned counsel for the respondent, has raised the preliminary issue on the maintainability of the writ. It is submitted that the statute holding the field contains an appellate forum, contains an avenue for preferring an appeal, and in any case, a writ petition could not be made. The Senate Council otherwise submits that even on merit, the order dated 23/3/20 is a reason for and has been passed by the learned tribunal by taking into consideration all the relevant facts and circumstances. The learned counsel for the respondent further submits that the petitioner is negligent in conducting the case and the same is spent since the year 2008 for faults which are attributable solely to the petitioner. He accordingly submits that the present case cannot be appealed or interfered by this court, which exercises equitable jurisdiction. The tribal submission made advance have been duly considered, and the materials placed would have been carefully examined. On a careful perusal of the impute order dated 23/2020, it reveals that the state date was fixed for cross-examination of the petitioner's witness. It further reveals that in the meantime, a cost of rupees 10,000 was already imposed upon the petitioner due to the previous non-appearance. This court has further noted that the learned tribunal has taken into consideration the conduct of the petition in the case which triumphs revealed that there has negligence in pursuing the litigation. The tribunal has also gone into certain facts regarding the reasons for adjournment, and this court may not be required to go into the aspect of those matters. However, pertinent to note that from the year 2018, the proceeding is pending and is only at the stage of cross-examination of the petitioner's witness, and adjournment was sought for on the ground that the concerned counsel was unaware. That while this court is of the opinion that dismissal on technical grounds may cause prejudice to the parties in a court, it is also really important to note the conduct of parties. From a reading of the impugned order, it primarily appears that there is lack of due diligence on the part of petitioner in pursuing the proceeding instituted under the Act. However, taking into consideration the legal status of petitioner number 1, which is a company, and also the nature of allegation, this court is of the opinion that the equity should be balanced by interfering with the order dated 23/2020 and remitting the matter back for adjudication on merit. However, such order would be subject to payment of cost of 50,000 to the respondent. According to the order dated 2020 passed by the learned students in LT case number 5 of 28 is set aside, and the matter is remitted back to the state tribunal for adjudication on merit. As directed above, such remission, as the order of remitting is subject to payment of cost as a it further directs that the matter be disposed of within a further period of 6 months from today, and was today in accordance with law, and the learned tribe would be at liberty to pass necessary orders on merit.
What we can do?
No,
You're
Lordship.
Coal India.
No, Lordship, because he has spent so much money
You're
here.
Coal India.
Yes, Lord.
Doesn't matter.
Did we say 5 lakh?
Yes, Lord.
Only 50,000.
10,000 euros.
May I enhance the pic?
10,000. 10,000.
50,000. If you had a person, you're big on. Yes, I'm-
Is the
For
coun-
that negligence,
is the
we have to
coun-
come here.
Is the council who that should be considered?
We've considered. Have not imposed more. Okay.
Obliged.
It is
Hey, please, your lord. Here the petitioner has prepared several petitions for removal of an illegal shop established on the road.
Illegal shop?
Illegal shop established on the road, which has disturbed the petitioners from
Affidavit
inconvenience
filed.
towards the interest and outrage.
What instruction? Get
So
instruction.
already DMCS issued one notice to the petitioner, Lord, page 28, Lord.
Which place?
Argoli.
Argoli.
In Guwahati?
Yes,
Guwahati.
Get instruction
already DMCS issued one notice to the petitioner, page 28, Lord.
to the petitioner.
Yeah, sorry.
To be that respondent.
Lord,
Okay.
So he is not a party here, Lord.
You have not written a part.
No, no.
Illegally establishing a shop.
But you have to make a party. Illegality is your contention. We do not know.
Whatever here, 26, page 26. Page
So, Mr. Sharmasi, you may be correct in contending that's an illegal thing, but that is your contention. Without
the
hearing,
contention page 25, Lordship, here. Page 25, Lord.
Yes.
25, Annexure 8, Lord.
Yes.
Lordship, regarding removal of unauthorized shop, Lordship. Here, they are.
Sharma, this is your project here. These are your documents. To make him a party, we will not be able to pass orders. Even if we pass, it will not be effective orders. Tomorrow he will come rush to the court. I may be affected, but it not made, not even notice. Make him a party. You have a good case, you have enacted notice.
Yes.
Make him a party. And you, in the meantime, you have this. Priya Sharma, let it process for the petition. So third Priya Sharma, let it process for the whereas the respondents are represented by
No, no, I'm for respondent.
respondents and Gustav United State Council and MS as to here for the game. The allegation is against lack of action to remove an illegal remove a shop according to remove a shop which according to the petition has been illegal constructed. The petitioner has also annexed a notice dated 18/8/2021 to the state that the right, however, appears that the state entity has not made a part respondent the letter for the petition. According to this, sometime to file the appropriate application for him. In the meantime, liberty is granted. In the meantime, the Senate Council respondent may also obtain necessary instruction. This after 2 weeks, enough. It may be fixed. File it. I will publish.
In this case, Lordship, respondent court has illegally constructed the building of this.
Against illegal construction.
Yes.
Where?
Guwahati, Lordship, here in,
Then what is that?
for that
It's
illegal.
the area for the illegal, illegally constructed house.
Your Lordship may direct the authorities to take necessary action, but as per law, my lord, I have no problem, my
Are you considering that it's illegal construction?
lord. I have constructed two extra floors, my lord. For that, it is compoundable, my lord. I am ready to pay necessary fine and all that, my lord.
Two floors.
Two floors, my lord.
It was for G+3 and he constructed G+6.
Already 4 has been regularized, my lord.
How it
G
is
plus 4 has
regularized?
been regularized. Now 5 and 6 are there, my lord.
He is a co-operator, Lordship.
So
That's one of
I
the-
have filed an appeal, my lord. Order has been passed in the appeal also, my lord. On 2/9/23, my lord.
You seem to be a very powerful person.
No, my lord.
What is your name?
Apurva Hazarika, my lord.
Oh, you are the brother of the petitioner.
Yes, my lord. Yes, my lord. So, but the GMC and GMT may be directed to take necessary action, my lord, on the basis of his application.
Why don't you sit and
Complaint,
talk?
my
Lordship.
Why don't you sit and talk? He might give one floor to you.
Lordship, I am
And your
affected
complaint will also vanish.
My lord,
I am affected because I will not get that FIR, Lordship. He has already consumed more than 400.
You are getting a floor. What are you talking about FAR?
But my land
You
will
need
be
not go that far
no, Lordship.
for an FIR.
I have
You
also
get a floor.
I have also equal share.
FLOOR.
Lordship, I have also equal share in that plot of land. That is a
Yes,
they are 3 brothers, Lordship.
yes, my lord.
Are
100%.
these compatible offenses?
Yes, yes, my
It
lord.
cannot be, Lordship.
Yes, my lord. Yes, my lord.
So you have to say.
If that is allowed, then it will be everyone will get if applied for G+3, everybody will get G+3.
How can it be compoundable?
My
Some
appendix,
variations in the.
my lord, appendix 3 of Guwahati Building Construction
How can you
Regulation
increase
bylaws,
the
my lord.
number of floors?
There is
Some area may increase.
My only thing, my lord,
You have increased to
that far
100 by 2
he
floors.
cannot exceed the far, my lord. That's the only thing, my lord.
No.
It says, my lord, additional extra floor to accommodate area within compoundable far, my lord. That is compoundable items, my lord. Compoundable items and non-compoundable items are there, my lord. In compoundable items, it is
How much is the area? How much is the area in one floor?
It is, my lord.
In square meter, it is there.
How much?
That has been maintained, my lord.
Now, how much?
192.48 square meter in
Was
ground
it?
floor.
Is it within the allowed FAR?
Yes, my lord. I have not exceeded, my lord. If
No,
it is not exceeded, then only it's compoundable, my lord. Because it notice there, my lord. Additional floor, which means, my lord, there is non-compoundable is additional floor beyond the compoundable part. If it is beyond the compoundable part, then it is not compoundable, my lord. It will be demolished, my lord.
Let us see your building permission.
At page, Lordship, Annexure 3, page 25.
25.
Lordship.
How much is the area?
The area is not mentioned here, Lordship, but number of floors is G+3, unit 4 number. And
Where?
That is right side.
Up to third floor only.
Up to third floor only with unit 4 numbers. He has constructed 12 units.
Unit 4 number.
And 6 floors.
And ground. The area is there.
Area of floors are there.
192. 190. Yes. What is your area constructed? Per floor? So, Mukhtar?
192.48 square meter, my lord.
No, that is the
the
permitted
permission.
area. How much have you actually constructed?
I think that is the area, my lord. Because first, second, third, all same, my lord.
No, that is the first, second, third. This is what is permitted to be constructed. Now you have gone.
As per permission, I have not exceeded, my lord.
Now then you have constructed 2 more floors.
That floor is there, my lord, but I have not exceeded the area, my lord. If I have not exceeded, then only it can be allowed, my lord. Accordingly, my fourth floor has been already regularized, my lord. Fourth floor has been regularized already, my lord. Same way I have constructed, my lord. On 9/6/2020, my lord, this has been regularized, my lord.
What is the meaning of a permission? Get permission for 1 floor. Go up for 10 floors. I have not exceeded area.
Yes. That is them. They take penalty
Area
in
is
all
not
these
the
matters.
area of
I have
the
to pay
ground.
heavy-
Area is
heavy-
the floor area.
A heavy amount has to be paid, my lord, for that, my lord.
These are not curable. How can you increase floors? Increasing the area by category was something setback, not those are curable. How can you increase the floors? And this is not something new. We had the precedent in 2012 or 13 itself. Big building here was demolished. So another will be demolished.
So authority may take necessary action as per law, my lord. That is only my contention, my lord.
Yes, what action are you contemplating? No, we are not on regularization. We are on his application. Regulation matter is not before us.
My lord, as per the application, I have to notice dated 2023 for my lord. For
Then what have you done? When was the complaint?
Complaint was
complete my lord, 21/11/2023.
21/11/22.
22. What have you done for the 1 year?
Notice has been issued.
Only notice. Who is
Total
the
notice.
commissioner?
Madam?
We'll have the commissioner here. 1 year he is issuing notice.
notice was issued on
23.
in May.
March.
This is how you treat a complaint. And you talk about pendency of cases. Where is your affidavit, madam?
We have not filed.
Okay, who is the commissioner? Let him
Madam,
come.
may take up after some.
Who is the commissioner? We'll let him come. We'll actually interact with.
And I may be allowed for P9. He is just sending. I mean,
We are not concerned at what are it, who is appearing. Let him come. Where is your instruction? We'll have this on Tuesday for instruction. If you don't get the instruction, you advise your client. That we don't want to cause any harassment to anybody, but if instructions are not coming, we'll have it. Third, Deboro, Learning Council for petition. Also heard. MS as petition. Learning Council appearing for GMC and GMD.
respond to one of the
One also
Right.
for the respondent. For the official. Three SK Mukhtar Learning Council is present for the phone number
4 and 5.
4 and 5. The petitioner has alleged that there has been gross violation in construction, which is the subject matter of the case, by referring to the no objection certificate dated 10/1/2019, the learned counsel for the petitioner submitted that while the permission was given for G+3, the private respondents have made constructions of
G+6.
G+6.
Yes.
G+6.
With 12 units. Only for 4 units, they may construct 12 units.
G+6 is further submitted that while the permission was for 4 numbers of units, the total units constructed is 12. To the private respondents have filed affidavit from the official respondents are yet to file the affidavit considering the nature of allegation, this court grants a final opportunity to learned counsel for official respondent to have the instructions on the action taken on the complaint of the petitioner, fixing the next date as on 22nd, failing which court will consider the requirement of personal repair of the concerned official.
May I plead your lordship?
Yes.
Lordship, the petitioner was functioning as a ex-president of 241 Nong Bhatia Keligao Panchayat in the district of.
You cannot function as a. You were the. You can function as a president. How can you function as a? You were the president.
Ex-president.
Now you are the.
Yes, lordship.
What is it? What is it? What has happened now? What is your demand?
The petitioner received only 17 months remuneration as a PRS representative. Now she is entitled to get 43 months remuneration from the government.
Who gives you the money? Who gives you the remuneration?
Finance department. Finance department. Similar matter.
Yes,
So, lordship,
President of Gaon Panchayat remuneration.
Yes.
Who pays?
Actually, originally by act, my lord, it was from their own source, my lord. But thereafter, some cases were pending. Now, our court decided, my lord, and to department, to the government.
What are your instructions here?
I have instruction that already cabinet has been, the matter has been placed before cabinet, and cabinet approved it, and they will be paid in 3 installments.
How many of you are there? You, Mr. Hussain. What is your name? What is your
Anjuara
name, Mr.
Begum.
Counsel?
Anjuara Begum.
Your
M. Hussain.
Your what petitioner? Let him have this. Priyas Dutta, Standing Council, PNRD Department, submit that in the meantime, there is approval from cabinet and the remuneration which are pending would be released in 3 installments. Please this case after a month to enable the Standing Council to update regarding the status of the process of release of remuneration. Obliged.
Obliged.
My lord, the issue in my writ petition, my lord, the item number 30, WBC 5720/2023. This is the, my lord, Lumding Municipal Board.
You for the board?
Yes, my.
Yes, what?
In fact, my lord, the issue is regarding the identity of land of the railways and the municipal board. The government notified the land of the municipal board long time back. But then, my lord,
what is the other matter?
Other matter is
by 38
my
numbers
lord,
of
notices who have received notice from the state officer under the Public Premises Act.
Okay.
And in fact, my lord, there is another writ petition filed by the railway authorities. My lord, their prayer is that the land should be demarcated. In fact, my lord, that is the solution of the entire
Yes,
problem.
yes.
Therefore,
What is that writ petition?
That writ petition is, my lord, WBC 4572 of 2020.
Not listed today.
Not listed today.
Are you protected by some orders?
Yes, ma'am.
Then we'll have the
3 matters together.
Mr. Dutta, I think that would be the best one.
I have already filed my.
Our PMP self-reliance in account. You're in both the.
No, ma'am.
In the first one.
I am 30 only.
In account in the 570/2020 and in the other one. And the B Sinha Current Council in the 598 of 2020. The subject matter is with regard a plot of land which according to petition in WPC 57, which according to the Lumping Municipal Board belongs to them.
Yes.
And our on the other hand, there is a similar demand, similar claim by the railways. The petitioners in WPC 5698 of 2020 are persons who are aggrieved by eviction notices issued by the railway.
Yes.
This court has been informed
under the PP Act.
that there is another writ petition, WPC
That is, my lord, 4572.
4572 of 2020, instituted by the railways with a prayer for demarcation of the plot of land in question. In the in the opinion of this court, fairness, it would be just and proper if all the three are taken up for consideration. This cases along with WPC 4572 of 2023 on after 2 weeks. Interim order passed. Who has filed?
Railways have filed.
In your case,
My lord, I have I am paying on 5720.
doesn't matter. It will be concerning them also. Give a copy.
We may, my lord, your lordship will give liberty to file the reply to their
Yes,
affidavit.
in the meantime, affidavit may be exchanged.
The Lordship may kindly see order dated 9/10/2023. Lordship. 9/10. This is my peculiar case, my lord. This honorable court has. 9/10.
Yes,
Yes,
my lord,
I'm
they,
paying for a private respondent.
they are in agreement, your lord.
Don't have any problem with that. Going to the facts of the case, if your lordship passes the first prayer that they have made, they just want to visit their mother whenever they visit it.
My lord, I am residing, I am working in Dubai, your lordship. Because of differences between brother, my lord.
Yes.
You want this
Visit and my lord, whenever I give call, my lord. Prayer number 1 is your lordship.
What's prayer number 2 there?
Prayer number 2 is, my lord, that at that, in case unfortunate incident happen, my lord, cremation and all, so they should inform me in advance.
That part will not.
My lord,
Yes.
32 prayer number 1, your lord.
Will dispose of.
My lord.
Yes.
What age of your mother?
Mother age is
70, 74, 75.
70.
A rather unfortunate case has been confronted by this. The petitioner son of late Vasanta Kumar Agarwal and Srimati Vidya. The purported mother of the petition is residing at Nagaon, with the respondent number 5, who is the elder brother of the petitioner. The petitioner is presently resident of Dubai in connection with his business.
I'm doing that on tourist visa, Your Lord, working there.
Connection with his work. The grievance with regard to the obstruction meted out to him by number 5 in his approach to meet his mother. Also stated that mother of the party is not sufficient age, but also very after issuance of notice from the private response has ended. I heard he going whereas therefore response number 5 whereas is present for to the grievance expressed in was a person and one common. This court has been tried that contesting party has arrived at a broad agreement that would permit it to visit their master as and when he is in India. In view of such activity from this court, there are no orders that be passed. However, expect that this is a personal one from the party would deal with the sensitive and not hurt sensitive.
Regarding phone call, whenever he gives call.
That is why she is suffering from dementia. And she's 75 years old. It might not be possible for her to pick up the call.
In that case,
You agree upon it. You not think.
Yes,
It is very sensitive. For as for what it wants for one deep
May I please your lordship? My lord, in this case, the petitioner's late husband has donated some plots of land for the construction of a school, and the condition in the gift deed is that the name of the school should be in the name of his father-in-law. Now, what happened, my lord, the school got merged with another school, that is Deshabandhu School, and the school got shifted to that premises, and the government is contemplating.
Yes, any
Instruction not received, Lordship.
An affidavit is not.
he is not asking for something extraordinary.
Yes, Lordship.
We have seen cases where dads are donated for jobs. It's not a job, it's he only wants the name.
He gifted the.
It's the name of his
land.
father.
Yes.
And since the petitioner is the lady, this is her father-in-law.
Father-in-law.
He have filed an representation before Deputy Commissioner.
Your initially it was named after your father-in-law.
Yeah, yes.
Kali Krishna. Now after the merger,
It is Deshabandhu.
Deshabandhu. You take the instruction. Yes, Sharma? Who will take the call? Education department or government?
It is
Commission. Because deputy commissioner has the letter and thereafter the employment exchange as the office of the employment exchange letter.
Not yet set up or it has been set up or they are contemplating setting
Hard
it up.
to be so that it can cost for the petition. Notice of question of the 70 both MSS Barua, President of Hugh Sharma, and sending on secretary for 3 weeks time. So,
My lord, interim order may continue.
what
Not to set up the implement order or setting up the employment.
the interim order passed at 10 the next day. May I please interrupt? Okay, I'm appearing in the 34 yellow. And Mr. P.N. Chaudhary is appearing in 35 yellow.
But 35 is the lead case, my lord, and 34 and 36 are his top foot.
Now,
Lordship,
we take up which pen?
35 first, my lord, if you lord.
Our case is a bit different. 2018?
Yes.
Why is it pending? It's not even
This much water has flown, Lord Sakupi.
still Sako.
Yes.
Have you come to the right court?
Yes, yes. In fact, issues have been almost sorted out. So far as we are concerned, Lord. My
Who are you?
friend will not agree to, perhaps.
Who are you?
But I am a society, my lord, who has been allotted the land.
You are together or you are
No,
conflict?
Lord, my
I
friend
am a
represents
member of the we are
some
the
of the
members
members.
of the society. You are together. There is no conflict.
Yes.
There is a conflict.
It has
which
now
is
ended.
pending
Sitting
before
together
the-
is,
okay. At time to sit together, then suddenly he comes to the other.
My lord, first, if we settle with the government, my lord, perhaps our internal issues may be sorted out. But perhaps. So now, my lord, what
The
has
matter
happened?
has not been resolved.
Now it has been resolved.
Resolved.
Resolved in the sense, my lord, we say that
Yes, 36. Similarly placed.
My lord, I have some land is encumbered me.
I told you, sitting together may not mean that you are together.
I'm saying, Lord, that they are against us, Lord, if I can say so. Anyway, Lord,
And oust him from there. Ask him to sit here.
Lord, he tried, Lord. He
did not
he tried, Lord, that attempt failed. Lord, I'll come to his petition later on, Lord. Primarily, what
Now
is
he is wiser to be with you.
No, I will not say so. Otherwise, that would amount to an admission, my lord.
Madam, resolved or not?
My lord,
This acquisition
I just-
proposal has been.
just in a brief, if I can indicate to you, Lord. So the petitioner society was given a plot of land measuring 30 bighas, Lord.
You are a committee.
Yes, yes.
Okay, then?
Way back, Lord. Now, what has happened, my lord? We had applied for permission from GMDA. So that
The plot of land of how much?
30 bighas, my lord.
Why?
For construction of our houses of the members of the society.
Okay, you are society. Okay.
Yes. And we had paid premium, Lord. 90s, 2000. Lord, we had applied for permission. At that point, the 2000 Act came. Water bodies. Lord, that was not included. Ours was a patta land. Therefore, we have approached your lordship that it should be carved out from the schedule. Now, we are doing the process, Lord.
Yours is a patta land.
Yes, patta land. And we made a submission, Lord. Otherwise, if you own water body, Lord, nothing is going to serve our purpose, Lord. Or the government should acquire. Now they have come up with a notification under 3 of the Land Acquisition Requisition Act 1964, which was placed before your lordship on last occasion. Now, my lord, they know, since it's something which is coming out of from these proceedings, Lord, Section 3 notification is for acquisition.
It is under the
requisition.
Assam Act.
Yes.
1964 Act.
So when they are taking it for, my lord, otherwise for permanent nature of making it a water body or whatever it is, my lord, but it's not something which is for the purpose is requisition. Otherwise, my lord, again we have to go for another litigation, my lord, saying that this notification may not be applicable for because it's for permanent nature.
No, acquisition is for what?
But they
What is purpose?
purpose is for making it water body. But they say they have included our land in the schedule of the water body. We contend it's a patta land. You could not have done it, my lord, because it's not a under the term. Now, or having done that, now if you want to acquire, you acquire it. So they have come up with a proposal that they will acquire the land. Now, my lord, the compensation could come under 2013 Act, my lord. My lord. And that can be also be done if read with section 6 of the 1964 Act. But they are coming up with a notification under section 3. Lord, when the purpose itself they know that there was no purpose for requisition.
Now, did you have any construction activity there?
But some part of building has been constructed in the part. No, because they did not give permission, so we did not make the larger construction part.
Yes, who is the parent? Are you acquiring the land? You have already notified.
Yes, my lord, it is
Now,
not.
what was the compensation part? They have
No,
the issue
for
has boiled down to the compensation part.
that, for to start the acquisition process, my lord. It is, notice has issued under P1, my lord. So under P3, there is a provision of 30 days period for objection.
When
my
was
lord.
the proceeding initiated?
It was by that letter 6-1, my lord. That
611.
611, my lord. That
Oh,
1-1
recent.
Yes, my lord. Thereafter, it will go for 6th, my lord, for acquisition process.
Then Mr. Dubey,
If that is the submission,
Mr. Dubey has said that.
then they could have straightway gone to 6.
No, what Mr. Dubey has submitted, Mr. President,
Yes.
that fair compensation perhaps is not be paid. But this is in the realm of contemplation.
Yes.
We do not know.
No,
Are they denying that paying off for
No,
fair
my lord, there are two aspects. If it is for a permanent purpose, then you cannot invoke this. The 68 rules cannot be invoked. There is judgment of our High Court. My lord, it can be invoked only in certain, my lord, temporary purposes. Supposing there is flood. Some
No, under the Assam 64 Act.
Yes.
Acquisition.
No, my lord. It has to be, if it is for a permanent purpose, then it has to be preceded by a, my lord, acquisition under, earlier it was under the 1897 Act. Now it is under the 2013 Act. It is always for a temporary purpose. Yes. Kindly see, my lord, section 6, where, no, yes, 3, my lord, if in the opinion of the state government,
Assam Land Acquisition and Requisition Act.
68, 64, sorry.
But are you agreeable to the proposition of?
Yes, my lord, if they eventually go to 6, my lord, we have no problem. In fact, my lord, the land was allotted to us. Now they say that we can't make construction. Then my lord might as well acquire it. And in fact, that is what the government wants to do perhaps. But by taking resort to rule section 3, my lord, our purpose will be frustrated.
Where are you?
Kindly see, my lord, section 3, which they have invoked now.
If,
yes.
6, it should be 6, then read with 3.
3 is requisition, my lord. If they want the, if they say that it will be followed by 6, then we have got nothing to say. I think that instructions we can
that
take.
will followed by 6, my lord. Requisition is followed by
Yeah, my
6,
lord,
that-
we can wait for some.
Madam, there's no question of requisitioning now. It is, you have already thought about what to do with the land.
My
It
lord.
will form a part of the wetland.
Yes.
Now you are not requisitioning for some purpose, then you acquire it. Straight away acquire it.
Yes.
Ultimately, the loss will be yours. You have to pay requisition and compensation and acquisition compensation. No, no, understood, but this, you have seen this copy, 6/11/2020, 603(1). There is no question of requisitioning for a day. It cannot be for a temporary.
For a permanent purpose, there cannot be requisition. Requisition can be for a temporary. There is judgment of our High Court on this point.
No, even paid meaning.
Yes.
You are not requiring the land for.
So I can appreciate, my lord, administration at times have some difficulty.
to start with, they made requisition, then only that statement is required. If they make that statement, my lord, will withdraw our petition. Oh, yeah. Papa,
Mr. Chaudhary, is it essential to invoke 3 before 6?
Not necessary.
But see the wording.
Yes, where any land has been requisition under section 3, state government may use or deal with in such manner as may appear to it to be expedient, and may acquire such land by publishing in the official gazette a notice to the effect that state government has decided to acquire such land in pursuance of this section. Where a notice of the aforesaid is published in the official gazette, the requisition land and premise sale on and from beginning of the day on which notice is so published based absolutely in the state government free from all encumbrances, period so and so, subject to the provisions of this act on such vesting, provisions of Land Acquisition Act with rules.
Slightly ambiguous.
Yes.
Slightly ambiguous. As if acquisition proceedings cannot be initiated.
Yes. Without.
Without. See. Maybe that is the understanding, and it cannot be said to be wrong also.
Actually, the practical difficulty of the government, my lord, today, my lord, if they want to go for an acquisition proposal, then that budgetary provision has to be there. They do not have. That is why they take resort to all these things.
We adjourn this matter, let them come.
Yes, my humble submission is, my lord, let them have the instruction when section 6 is come. And in that,
Mr. Mazumdar,
subsection 3.
You are similarly placed, Mr. Biswas. This case is Biswas, your case. No, we are adjourning the matter otherwise.
Yes, yes.
But why Mr. Mazumdar's case is different?
I have given the land has come.
Well, I think.
So you will be
I think their remedy lies in either civil court, not in this proceeding.
No, those matters will be, but ultimately it's a question of apportionment. Those can be
My
sorted
lord,
out.
we entered into an agreement with them because we thought that we'll get the permission and the construction would be made. Now things are different. Now it is beyond my control.
Who are you?
He's a builder.
I'm the member of
No,
this.
I'm the builder of
Now, my lord, yes, at best.
Your objection to an acquisition proceeding perhaps be difficult to adjudicate on
Yes.
your instance.
This has come after I had
Third, case or if the consequence the arm in respect with third government the state council. The Nayak to repeat for the Nayak the state council and portal and cabinet for that is formal the state council has been put communication with 611 from which it appears that the land in question has been petitioned under section 1 of some land petition and acquisition Act of 1994 by LA 35 /20 /4 that the purpose for which the proceeding is of permanent nature and therefore instead of notification of the act of it's section 6 but section 6 of the act anticipates that the acquisition after of that that is PHO, by a period among when a particular object of it yeah,
Regarding acquisition of the land.
on the further step regarding we have this in our record. Copy of
That may be kept as a record, part of it.
is kept in the record.
Obliged.
I'm taking 2 weeks time to file affidavit. I'm taking time for the first time. Earlier petitioner
He's taking time for the first.
for the first time.
My lord, 15 was straightaway violated, my lord. If he makes whatever he wants to write, my lord, he cannot survive, my lord, possibly.
What's your case?
My lord, I was a president, my lord, elected. Thereafter, there was a no confidence motion, my lord. I was removed, but not without following the mandate of section 15.
The government,
my lord, exactly. My lord, 15 days, instead of that, it was sent to the Anshalik Panchayat on the 12th day, and that is absolutely fatal, my lord. That situation cannot be retrieved by my planet.
how many? You have one more month there.
Exactly, my lord. That is sooner the better, my lord. Again, I by following the due process of law.
Why are you coming for 1 month? Some collection is there over.
Yes, my lord.
Collection time.
My lord, we filed it long back, my lord, to be very precise.
2023.
No, you said 23, my lord.
2023 is not long back.
Requisition was on 29.
Requisition was on 29/5.
But ultimately, when was it?
Ultimately, it was 29/5 resolution, my lord. I was removed.
5 days notice was endeavor will be made.
And my lord, the notice
Are you
was-
protected by an interim order?
No, not at all, my lord. Somebody else has come in between, my lord.
Order dated 5/6.
You are for whom?
I am for requisition.
How many?
9.
9.
No, I have, my lord, that point, my lord, democracy, democracy is with him, my lord. But the process of law, my lord, section 15, Lordship knows more than me, my lord, with all respect.
No, it's not right.
No, I'm not saying that, my lord.
But 9 are against you.
My total violation, it cannot be carried out in this manner.
Now, in the court, we can say 9 are against you.
Yes, my lord.
Then
That,
what is there
that
to- what is there to decide?
resolution was taken, my lord. So far as the
We set aside the resolution, we will pass a new resolution.
absolutely, my lord. So immediately today itself, my lord. At least for some days I will be there. My lost space, I'll regain something.
No, we will not allow you to sit on this same chair.
Well,
Unless we'll give granted time. Are you agreeable?
Better will be infectious, my lord.
We'll fix a date. We'll allow this.
My lord.
We'll allow this petition. Are you confident about 9?
Yes. Then they
Possibly, my lord, situation may now change, my lord. That is why I'm hurting.
And
you are slightly shaky.
And meeting was convened by on the direction of this honorable.
No, that's a wrong interpretation, my lord.
Observation of
Without the court never said don't follow 15 and carry it out, my lord. That is exactly that, my lord.
Let us see the earlier order.
Yes.
Page 23.
Thereafter, they filed an IA, my lord.
Page 27 is the lordship observation.
Well, 27 would be the relevant date.
You had approached this court earlier.
Earlier,
Why?
yes. As the meeting was not convened by either Anshalik Panchayat or lordship, no authority, then we approached this honorable court seeking direction for convening them.
Yes.
Then in pursuance of this order,
notice.
Lord.
27 last paragraph, my lord.
Observe cannot be a bar. When did you initially issue the notice?
Initial date of notice, my lord.
14/3/2023, lordship.
And the meeting was ultimately held when?
29/5/23, my lord. More kolu. I don't know, no issue, no issue, no issue.
29/5.
My lord, my lord. And there are then, my lord, application
And
file.
you are taking the ground of violation of time under 15.
Absolutely, my lord.
From 14/3, the meeting could ultimately be held on 29/5.
Because of, my lord, they moved High Court first, my lord. And they say at the direction of the High Court, my lord, 15 was given a goodbye, my lord.
They have not said.
My lord, exactly, my lord, why meeting was held. Then 7 days gap, my lord. It
Where
was
is
held
the
after
imputed order now?
page 28. My lord.
The
My lord, that 29 would show, my lord. Possibly the High Court, Honorable High Court's order was misinterpreted, my lord. 29. As per direction of the Honorable Guwahati High Court, today on 29/5/23, at our High Court never directed that the meeting be held on that date, my lord. High Court said in accordance with law by following 15.
What's your purpose? Not be served. He's taking for time. Cannot force him.
Let it be, my lord,
How soon can you file your affidavit?
day after tomorrow, my lord.
On Sunday, will not come.
Oh, I'm sorry, my lord. I'm sorry, my lord. I'm sorry, Monday.
Tomorrow
my
also
lord.
we are thinking whether to come or not.
No, exactly, my lord. Same position remains, sir. Can it be on Monday, my lord?
How soon? Can you file it tomorrow?
I may file by Monday.
Monday you file. Or Wednesday you will have this matter.
My lord.
Third,
Highly of
for the for numbers
8 to 6.
8 to
16.
Submit that you file the affidavit. Mahajan of exercise as there about month for period of day.
My lord.
That yeah, right. By
20.
by 20.
Highly obliged, obliged, obliged. My lord. My lord.
Obliged.
May it be lordship. Lordship, the petitioner is a registered dealer under the GST, lordship. Could not file the return for 6 months, therefore his registration certificate was cancelled. Lordship, page 70. Lordship, I have not listened to, but lordship, what happened? There was a amnesty scheme that was valid up to June, that was extended to August. And but now again, type of case that.
That was
yes. No, this is the month of February. It was registration was cancelled.
Which the order?
Last page, page 71.
Similar order.
Lordship. But they have to comply with rule 23.
We have said here.
Yes, it is there.
Agarwal, can you make the correction here?
Lordship.
Take out a separate copy.
Lordship.
What copy? Make the correction.
Lordship.
But
only the notice dated will be
But is it connected to COVID-19?
Lordship, at the relevant point of
Which
time,
was the period?
Lordship, that is 2021.
During which month?
The so-called notice was issued in the month of January 2021.
They
have not specified that for which they defaulted. Simply said that. Lordship, now up to 31st March 2023, I already filed the return under the GST.
Disposal.
Deep leverage.
Give it to our court mark.
Deep leverage.
May I please, Your Lordship? Your Lordship, for impeding Srimati Kirti Jolly, DC of Kanpur Rural, as respondent number 4, we have filed an amended first title.
After the imprisonment?
For impediment. After the impediment, we have filed the amendment.
Imprisonment was allowed on 25/8.
Yes, Your
Imprisonment was allowed on 25/8,
Yes, yes, yes.
Thereafter, it filed this.
Yes, Your Lordship.
Okay,
It was
no.
allowed in IS Civil 1111/2023.
Have you, has notice been issued?
No, Your Lordship.
Who's the newly imprisoned?
Kirti Jolly instead of Kamal
Number
Kumar
4.
Pushya. Yes,
Number
Your
4.
Lordship. Number 4.
What's your name?
Richa Jha.
Arjha.
Yes, Your Lordship.
You're not on record. You're with whom?
Sumi Medi.
Arjha. For the petition, submit that pursuant to the order dated 25/8, amended first title has been filed. Further submit that notices are required to be issued on newly implemented respondent. 150 has been served.
No, Your
Then you have to take steps for all of us. Did you serve notice upon anybody earlier?
Earlier it has been served, but not after impediment of this name.
Understood. Who has been imprisoned?
Kirti Jolly.
Kirti Jolly.
Only Kirti Jolly.
Did you, where is that treatment application?
It was in
I
IS Civil 1111/23.
Notices have not been. No. Issue notice to the respondent. That step be taken for where is that possible? Step by Monday. All the respondents, they have not issued.
Obliged, Your Lordship.
Maybe. Actually, this is the civil bench for matter. The conflict. My lord, last I have completed the new incumbent matter here. The respondent number 2 is the new incumbent matter. I have completed this.
Respondent number 2?
New incumbent has been joined in this.
You would file IA?
I have filed IA, my lord. It is disposed of, and accordingly there is
Respondent number 2 has been completed.
Yes, sir.
You have filed
But notice has not been issued to the respondent number.
Notice has been issued?
Not issued.
Have you filed amended?
Amended, but yes, ma'am. Yes, ma'am.
You filed?
Yes, ma'am. Course title has been corrected by
Akashdeep.
Akashdeep, yes, sir.
One has been served or not?
One has been served, ma'am. There is transfer.
Your A-Boro.
A-Boro, yes.
The A-Boro done a conflict petitioner has submitted that pursuant to the order 1776, the present principal secretary, BTC, has been added as the responsible to issue notice. That step taken by registered post by Monday. List of 4 weeks along with service.
Lordship, as per official Plausible court order, my lord, 10-11, my lord. The service upon the respondent number 7 is complete, my
lord. 7.
Lord.
Who is 7? You are for 7.
I am for 5 and 6.
5 and 6. Who is 7?
Not appeared, my lord. But service complete.
Affidavit 5.
Yeah, after that, 3 time may give.
We have no role. Municipal board has directed.
Are you protected by anything?
Lord.
Good.
Lord.
You file the court
Affidavit.
Who is 4 and 5?
4 is municipality board, Nalbari, and executive officer,
5 and
5 and
You file the affidavit. In the office dated 10/11/20. Service upon itself. The learned counsel appeared respondent and are done. 3 weeks time, file a the password.
Lordship, this matter may kindly take with WBC number 6838.
Tag along with
WBC
it is submitted. The WPC
6838
6838 of 2023.
22.
Is similar. Please along with the offer. 6838.
Awesome.
May pleases your lordship, my lord. My lord, here we have filed one IA application, my lord, for implementing the authorities in the requiring department, my lord, DIG SSB, my lord, as a party in the contempt petition, my lord. And we have issued notice to him, my lord, at page 18 of the IA application, my lord. Because IA of 288, my lord, my lord. At page 17, this is the communication by the deputy commissioner. He has done his part. Last para, my lord, he has requested the requiring department to release the amount. And the requiring department, my lord, deputy inspector has not released. And my lord, we serve a copy of the notice, page 18, my lord, 7/8/2023, to comply with the order of the court, honorable court, my lord, my lord. Everyone his imprisonment. Yes. Or for the applicant petition who by means of this application has paid for implementing the company holding the post of Deputy Inspector General as HQ SSB Rania as response number in the connected contempt case number 75 of 2020. Para 3, Staff General Counsel has referred to the communication dated. Where is Malad? First communication page 17. No, executive. Yes, Malad. Communication dated
18.
8/6/2023 and 7/8/2023. Notice. Addressed to the present incumbent requesting compliance of the order. Para. That notice issued on newly it is submitted that despite of receipt of such notice, no action has been taken for compliance. In view of the above, implement application is allowed and the executive policy is implemented as response number 2. I according to them dispose of main contempt view of the order passed date, that is 7 in I 288 of 2020. The executive policy is completed as the response number. The Internal Council for the System is according to direct file amendment was that notice be to the state to the newly by registered post service by obliged. There are list of the 4 along with service.
My lord, I am in the case item number 41. It is the fact is the same, lordship, and the IA is 2829.
Executive policy and communication.
Communication is same. Same. Yes,
Yeah. You file I
To the lordship. Lordship, this contempt petition has come up for motion to the lordship. Lordship at this stage, lordship notice.
the order.
Order is dated 36/2022. Lordship will find it at page 16. It's a common order and judgment, lordship.
Operative portion, Lordship will find at page 86. Direction. Lordship. What's the forest royalty matters? Lordship, in absence of any contract, page 85, your Lordship.
All right.
Roman 3, page 85.
It's a direct. This paragraph nine. This paragraph.
Lordship, yes. So, Lordship, the operative part is a Roman 2, your Lordship. The next page, page 87. There where there was that they shall verify in case it was payable. Next page, Roman 2. You'll find in other cases, the employer shall forfeit, release the pending bills, security deposit, earnest money, etc. if these are withheld against forest royalty. So, Lordship will find that part in page 85, direction, page 85. Roman
How
3.
do you explain the
Lordship, we find it well within time, your Lordship. Lordship.
Hey, Lordship. Lordship, it was filed in June, my lord, and it was matter was listed on 23rd of June, but it was left over, my lord. Since then, my lord, today the matter. 21 June. Yes, my lord. Matter was. The order is of 31. Yes, my lord. It's made of 3-4 months. Was it defect? No, my lord.
The matter was left out. Your Lord.
Madam, press matters. Hard. And put up.
Lord.
As great. And then not compare. Just not 30. Every 27. The council has all effort the notice dated 6/7/20. It should be some basic compare that by 6 that step for service of self-payment. This chapter 4 now is the
Direction was issued on 12/9/2022 to pass a speaking order within a period of 6 months regarding settlement of land in favor of the petitioner.
Yes.
To sort out these issues, the date has been fixed for hearing among the petitioner. And
when
23rd for 11.
Third year permanent council. 3 years of Senate Revenue Department.
That's not one the contempt petition.
The contempt
Yes.
For purpose 1 and 2.
One I am doing.
One has however submitted that as per instruction 2311 has been fixed for hearing matter connected to the judgment of the subject matter. In view of the above submission, is this case the third week of September, on which the court may be apprised of the outcome of status of the
That may be.
Obliged.
May I please observe? Your Lordship, willful and deliberate violation of order dated 7/06/2023, Your Lordship, passed in WPC number 5316.
What was the order?
At page 13, Your Lordship. Yes, Lordship. Operative part is. Yes, Lordship. Operative part at page 13, Your Lordship. Paragraph number 10, middle portion, Your. Today's Thursday.
Who have complained or not compliance of the order itself passed by it every type of it. The Learned Council has also referred the committee it to the incumbent request compliance of the order. That is with the board which are
MD Club.
This contempt is for non-compliance of the order dated 19/12/2022. The order is at page 10. Operative part, Your Lordship, paragraph 6. Next page. Regarding non-payment of bill.
Third,
Page 13.
third is put to the video.
Video direction was
Then
to be served to the video. I have served to the copy to the CEO also, Your Lordship, and Commissioner.
the commission is that this case.
Page 16.
What about the video?
Yes, Your Lordship. It is in page 14, Your Lordship.
14.
14.
Where?
It's still, Your Lordship, without representation.
Here.
Yes, Your Lordship.
So that third keep the third of communication by which
May I please? My lord, the order lordship will find at page, my lord, 11. And authority part, my lord, page 12, paragraph 5, my lord.
Where is your
My lord, page 12, paragraph 5.
what is the
My lord, they have, my lord, restrained the petitioner to harvest the, my lord, Kali Pedi, which are fit for, my lord, harvesting.
where is the order?
My lord, yes.
What is the
10-3, 10-3, my lord.
10th?
Yes. Yes, both the order, my lord. Yes. Now, my patta land, including the, my lord, dwelling houses, were attached by the landed magistrate. That has been stated by this honorable court. Next page is the, my lord, another impugn order.
The order do all
Now, since, my lord, the cultivated land,
you have to pay for order by permit to do the activity or
yes. Yes, that is why, my lord, he has filed a petition before the, my lord, concerned authority. Lordship will kindly see at page 17.
if that is rejected, that is the subject matter. How can it be contempt?
Now, since the order is not complied, because the, my lord, red janda, the red flag, my lord, that is not removed. Once the stay is granted,
Where is the order of removing of the red flag?
now once the order is stayed, proceeding is stayed.
That will amount the contempt is the nature of a criminal proceeding. We will not go by assumption. Until and unless there is a clear-cut order, you may have a cause of action. We are not denying. May not be a contempt.
Now,
contempt is willful violation. They have understood different, and there is nothing to retain to remove the red flag or to allow you to indulge in the activity.
now,
You want to do certain act, file an application and consider. That will be a criminal case.
yes, my lord, initially, my lord, criminal contempt was filed, and it was, my lord, placed before the register of this honorable court.
Criminal, it's not different.
Yes.
Criminal contempt is different.
Then it was.
Some activity in the court.
Yes.
There are civil contempt of civil nature. No, we are only saying that the criminal rising out of criminal. Doesn't matter. It can die, but this is not cannot be deemed to be a contempt. You file application, seek permission to allow it. If there is an order of state.
My lord.
But the who has complained about violation of the order 2696 passed by in criminal
Case 11, my lord.
One zero three of court has noted that by the effort and order the impute proceeding of mark number 8 of 2022, pending for certain executive magistrate, Oja, Sankadev Nagar, and the orders passed and the orders dated 10/3 and 77 hours thereof have been paid till the returnable date. Senate Council submit that the petitioner has not been allowed to harvest the Charlie SHKLI Eddie in the land in question, which according to him was violation of the aforesaid orders. That in the opinion of the court, the order cannot constitute to be a positive direction to the petitioner to indulge the act as aforesaid. The records available to the petitioner is seek for direction of the change instead of filing alleged that few of them are rules, however, referred to the file appropriate direct appropriate
Development.
Right.
Publish. Maybe, as per office note dated 15/11/2023, my lord, service of response number 6 and 8 are complete, my lord. And my lord, the deputy commissioner filed their affidavit saying that on the basis of my
you file affidavit.
Deputy commissioner response number
Section
3,
8,
my
who
lord.
is section?
Deputy commissioner, my lord.
Section 8.
My lord. No, my lord. Three, response number 3.
So who's section?
605 response, my lord. They're saying that they will take action, my lord. They already they have inquiry have been done, my lord.
Office note 7 reflect that the private response have service according to the number 3 has filed a list of list of the the other filed.
Only, my lord, my praise dispose of my representation, my lord, which is pending before response number 3.
What is the
Enquiry has been done on the basis of the enquiry report made by the Block Development Office. The paragraph 4, page 71 of our.
we'll have this for disposal.
This will cover ours and also.
What about the others? List of 2 weeks. Available. The private on this based upon the pass further
May I plead your lordship? Lordship, I am praying for a striking out the respondent number 3, my lord.
file application.
My lord, I have
Third. Last
my lord.
third.
Lordship, we have objection, we have filed objection also. This election petition arising after, here's the returning. Yes, sir. I was the election petitioner before the election tribunal. Respond number 1. Lord.
What objection do you have?
He was the returning officer. His affidavit will be required.
They suffer that but hard for deletion of 3.
My lord.
However, this
Obliged.
Yes, may I please your lordship? Your lordship, as per office note dated 14/11/23, service is complete as per as regards respondent number 5A to 5B.
Madam, you appear to
But I'm for respondent number 1.
file,
With the waiting.
not file. Office dated 15/11/2020 reflect that service for number 5.1 or 5.3 and 5.4. Other respondents have
Yes, sir.
the service record to help. The response a file affidavit for which
Obliged.
May it please the Lord. As per office note dated 14/11, neither AD card nor regarding respondent number 7. Lord. Sir, postal journal says my lord on 3rd of November. No, it's only 1910 it was passed. We'll have it up to have presumption. My lord. Notices were dispatched by the officer on 1910 and as per office noted 14/11 neither AD card nor answer as feedback. List of press service. Press no. Service report. I am out.
May I please the Lord? As per last order, your lordship, the election has already been held here.
Election held?
Yes. Yes. Now the results by captain is still over as per the order of the honorable court.
Yes. You have a habit.
Yes.
Have not.
But there is one common order, your lordship. That order is passed by your lordship in page 47. I am taking disposal of this petition in the light of that order here. Yes,
today it cannot be possible.
Yes.
Sort of like yes. Can I have it tomorrow?
Yes. Yes.
11 o'clock. submit that the matter can be closed up terms of construction and orders passed implement. And this for
It may kindly take up IA 3348
for
implement, my lord. My lord, the National Highway Infrastructure Development Corporation Limited needs to be made a party here. So they may be implemented as respondent number 13, 14, and 15 in the writ petition.
third step move by the application as state of 3 new incumbents as respondent numbers 13, 14, and 15.
15, my lord.
So, submit that the aforesaid respondents are necessary parties and there will be necessary for a complete you will be appealing for those.
They can take.
Can you accept for 13, 14?
Yes, yes. They are the council for
in view of the for submission of the present I is allowed and the incumbents, namely 13 are treated as respondent numbers 13, 14. B. Borua, A. Borua, when it comes to who appears for respondent numbers 10 and 11, submit that he can also appear for according to the service upon newly implemented for help that extra copy will be served upon 5 months.
5 months.
Highest as a good.
My lord, amended post title has corrected post title has
in view of the order passed, that is I 334 by which implement of response to 34 now, the petition got filed amended prospect which can be done in a period.
my lord. Date may be fixed, but
Fine.
obliged.